Sir, with your permission, should we begin with the introductions and then we'll continue with the lecture?
Yes, please. Yes, please go ahead.
Okay. Okay. So, welcome everyone to the second edition of the Advanced Certificate course on Space Laws and Aviation Laws. For today, we have Professor Sandeepa Bhatt as the first speaker, and he'll be taking introduction to space laws today. Sir is a professor of law and director of the Center for Aviation and Space Laws at NUJS Kolkata, with over 21 years of teaching and research experience. Sir was also the first Indian Unidroid correspondent. He is also a recipient of the Sachdeva Award for Space Law 2022 and a member of ISRO's expert group drafting India's National Space Act. Sir is the author of 11 books and over 70 articles and has presented 170 plus research papers globally, including one at the International Astronautical Congress. So please join your hands in welcoming sir. Over to you, sir, for today's lecture. Thank you so much for joining us today at the Legal Voice.
Thank you. Very good morning to all of you. It's indeed a pleasure to see more than 180 participants in this the platform. I'm really glad to find aviation and space laws are actually becoming something of interest for everyone. That's very great news for aviation or space lawyer. Now, and I should also actually congratulate Legal Voice for having the voice amongst such a huge number of audience. Congratulations to you as well. Let me just take a minute to share the slide. Is it visible?
Yes, sir.
Yes, sir.
Great. Yeah.
Yes, sir.
So if you can switch on your camera, that would also be great. I can also see you and then interact. And instead of having a one-way dialogue for next to 2 hours, it's always better to have interaction and then learn it together. Now, let me first ask you a question. Should we study air and space law, or should we study them separately? Aviation law and space law separately?
So separately,
Separately, why?
um, I think they both are much similar, but as a discipline, as a law discipline, they are very much different.
Much similar in what context?
Um, Mainly in like relating with the um, I could be wrong because I'm very naive. My answer will be very naive. I think
Mhm.
aviation is much more related with the aeroplanes and all that, and
Okay.
space is something which I think satellites
Mhm.
and any other thing which related to
What
the space.
similarity? You said actually it's also similar. What similarity you find?
Sir,
Not sure.
not sure.
Atharva,
Hello. Yeah, good morning, sir.
good morning.
Good morning, sir. The difference which I feel between aviation and space law is aviation generally deals with the airspace within the Earth's orbit,
Mhm.
where within the Earth and space outside the Earth. So these two creates a difference here, and
Okay.
similarity which I feel is both of them don't have a land or water contact with each other. What water contact? They both are in air
Mhm.
or without
Above,
any
okay.
solid above the
I'm asking about actually the law. I'm not asking about actually the atmosphere or maybe the region per se. In terms of law, is there any similarities?
Sir, I think they regulate their vehicles and activities within their respective domains. Particularly, I think concerning their safety, liability, and operational procedures. I
Okay.
think they they are similar, I think, in this context.
Hmm.
Sir, if I may,
Yes, please. Yeah.
just like the international law of seas, countries can also claim part of an airspace. So that is why aviation law has to be studied separately.
Separately
Whereas
from.
space is something which is to be explored, and therefore no one can claim anything in space.
Okay. A good answer. Good answer. Let me actually take this and carry it forward. Right. Uh, why I'm not in a position to change the slide? Can you see the change slide now?
Yes, sir.
Yes, sir.
Right.
Yes, sir.
Right.
Am I audible to you?
Yes. Yes.
Yeah, I would like to comment on that, what your question asked.
Yes, please. Yes. Yeah.
I think so. At the end of the day, what we are talking about is a law.
Mm-hmm.
And when it comes to law, we are talking about the human being interference or interaction with each other. So, protecting the interest of everybody, you need a law.
Mm-hmm.
So it is always a part of the law, where
Mhm.
either it is air, space, or whatever you say, because at the end of the day, human will be talking and doing all the things, and we need to protect with their own interest, either nationally or internationally. So the law
Mhm.
is there to protect, the things. So it should be the greater part of the law. I mean,
No,
the
I
favor of it,
accept
it
that.
should be the
My
part.
question was different. My question was actually whether they have to be studied together or separately. Or is
Together,
that the
that I said. As I said, it is together.
together?
It shouldn't be a
if I may
separate thing.
add,
It should be together with the law.
Okay. Okay. Uh,
Yeah.
right. Now let me just tell you why did I ask this question? To be very precise, aviation and space law are two separate branches. They are two separate branches. Space law has emerged as an independent branch. And one answer which I got somewhere in between was primarily with respect to the sovereignty and the freedom. Right? So, because airspace is subject to the sovereignty of the state which is below that is something which is having the sovereign right over the airspace. But whereas outer space is subject to the freedom of the state. Principle applicable therein is not sovereignty, it is the principle of freedom. Right? There are certain limitations are there. It is not that actually it's without any limitation the freedom is enjoyed. But subject to limitation, outer space is subject to the freedom and not with the sovereignty. These two concepts are quite contrary to each other. And consequently, the laws which have developed in aviation and space are also completely distinct. They're completely distinct. I'm not saying that actually you can't have a course on air and space law like the one which they are offering, right? I'm not saying that. What I'm saying is that it cannot be studied as a single discipline or a single subject. Why? I always tell my students, studying aviation law along with space law is nothing but studying tort law along with criminal law. Not even taught with the Consumer Protection Act, because they are not even complementary to each other, rather they are contradictory to each other. Right? Since the basic principle applicable to the airspace and outer space are quite different, the sovereignty and the freedom, all laws which have been developed in these sectors are also completely distinct. Let me give you a simple example. In aviation law, any damage, whatever has been caused by the aviation activities, the concerned company is liable. The private entity, whoever is carrying on the aviation activity, right? The carrier, in case of actually any damage to the passenger or maybe the cargo. And in case of actually the damage caused on the surface of the operator of the aircraft is liable to pay the compensation. On a contrary note, if you look into the space law, who is liable to pay compensation?
The state is liable.
State is liable.
For the activities of the any government body or even by any private body.
Even by the private body, right? There's a state liability.
The liability convention covers that.
Correct. There is a state liability which has been actually imposed under the space law, but with aviation law goes with the private liability. You have complete distinct set of norms with respect to registration. Aviation law's registration is different from space law. You have completely distinct norm applicable with respect to jurisdiction. If some activity happens in airspace, who has the jurisdiction? If some activity happens in outer space, whose jurisdiction will be there? You have completely distinct norms. Right? Applicable municipal law for different kind of private activities, they're all distinct. So precisely because of that reason, aviation law and space law are not even complementary to each other. They're contradictory to each other. Right? That's why I don't accept that there is one subject called air and space law. It's always air and space laws. It is plural. Right? Aviation law is distinct from space law. And that's the reason why my center's name is also Center for Aviation and Space Laws, not law. Right? They are two distinct branches. Other thing is that both aviation and space laws have developed to such an extent that you can't cover it as a single subject in a semester. Tremendous developments have taken place, right? So people might not be understanding the breadth of the aviation and space law. I always tell that, I always challenge anyone who says, I can develop a course of 120 hours each on aviation and space laws. 120 hours I can develop, and not beating around the bush. The core aviation law, core space law, 120 hours each I can teach. That much is there. That much is there. Right? And what industry requires now is the expertise. It is not just a peripheral overview of aviation or space law. It's an expertise which is required, because see, if you look into the space, currently, so much of developments are happening in terms of the private space activities that unless and until you have the best of the best expertise, you'll not be able to fight a case. Technological development, and even actually there's the minute legal aspects which crop up out of the space activities, one cannot imagine. If I have to give few examples, see, every private space activity should be licensed, right? The private player need to take a license. There would be a body to license it, and the private players need to comply with all legal norms to get a license. Who will help? It should only be by a lawyer who has all the knowledge of that. Then every private player need to enter into multiple contracts. Every private player need to enter into multiple contracts. Hundreds of contracts they need to enter, because see, maybe in terms of launch services, they have to take launch service of someone. In terms of procuring the parts of the satellite, they have to take from some people. In terms of hiring different services, they have to take from different people. So likewise, they have to enter into contracts with multiple people. And each of these contracts need to be very precise, because it would attract huge liability in future. Right? Each investment is in $1 billion. Each activity runs into $1 billion. So therefore, the contracts need to be vetted very, very thoroughly. And unless and until it is very precise, there would be problems. So you have the best of the best legal experts who need to vet these contracts. And there is huge stake involved. I recently interacted with a European lawyer in a conference in Delhi, and he was saying that he just vetted a space contract for which he charged $500,000. I repeat, $500,000 he charged for vetting a contract. Right? So this is the kind of a stake which is involved in the space activities or a space law practice. And this cannot be done unless and until you are having the best of the best expertise. So that's why I always say that space law is an independent branch, and you need to venture into that very thoroughly for the purpose of developing the practice in it. And even in India, it is going to happen pretty soon, because with the private space activities being permitted, and also more than 300 startups who are ready to invest in the space sector right now, you can expect actually a lot of practice in the near future. Right? Until now, we did not actually explore too much into the space law practice, but it is going to happen in the very near future. There are many companies who are consulting me. As of now, see, I didn't charge anything because space law is so close to my heart. It's all the pro bono work which I am doing. But as the time progresses, there will definitely be more litigations, more issues coming out of contracts. All of them would require the practitioners who would be taking it before the courts of law. Right? So a lot of development in practical terms is happening. Now, again, the slide change, I'm having problem. Right, yes. I think I have to change it every time like this. Okay. My topic here is more in terms of an introduction to the space law, how it has developed, and then what kind of principles have come up predominantly in the Outer Space Treaty is something which I have to discuss. I will also touch upon certain practical problems which are arising out of these the principles. To start with, 20th century has been a century of remarkable achievements. You can find that in the first half of the 20th century, you have the advent of atomic energy, of course, resulting in destruction. The Second World War resulting in destruction. But still, it's a scientific achievement. There is no doubt in it. And the second half of the 20th century saw the pleasant event of the space exploration. Starting with
The moon exploration.
Sputnik. Sputnik.
right. The Sputnik 1 was the first space object, right, which entered into the space. The former Soviet Union launched into the space.
Yes, 4th October 1957.
Yeah, 1957, 4th October 1957. Okay, great. This triggered a race between the US and USSR because everyone was astonished with the Soviet achievement. Nobody thought that it is possible to breach the Earth's gravitational force and enter into the space for eternity. Soviet Union did that. Once it did, everyone was astonished, but the United States was unhappy, of course, because due to the Cold War problems between them, the United States thought that it is going to achieve this first rather than the Soviet Union. But unfortunately, that did not happen. That's why they were in a way humiliated. And by virtue of that, in the very next year, United States launched its rocket to the space. That was Explorer 1. They launched the Explorer 1 into the space in 1958. 1959 saw another major development in terms of the space activities. Does anyone know what happened in 1959?
Sir, a resolution was entered into at UN with regard to space.
That happened from 1958 itself. In the 1958 itself, a resolution was adopted. I'm asking about any technological development or space venture which has
So I
taken place.
think with regards to space race, the Luna project in 1959.
Luna? What happened with the Luna? Any achievement which has taken place?
It was able to reach the vicinity of the moon.
Just vicinity of the moon?
Yeah, and the first to impact the moon surface.
Yes.
Luna 1.
Luna 2. It was Luna 2, not Luna 1.
Oh,
Luna 2
Yes, sir. Yes, sir.
had a crash landing on the moon in 1959. This was an intentional crash landing, right? Not an accident, because Soviet Union wanted to study the surface of the moon. They wanted to see whether the surface of the moon is very hard, rocky, or maybe sandy, in what manner it is. For that particular purpose, they had an intentional crash landing on the moon in 1959. So that was the first object to reach to the other celestial bodies, right? So that's the first object to reach to the celestial body. 1961, which all of you must have studied. What happened in 1961?
Sir, Yuri Gagarin became the first person to go into space.
Correct. Yuri Gagarin became the first human to be in space, right, in 1961 on board Vostok 1. Again, a Soviet Union achievement. On board of Vostok 1, he entered into the space. 1966. I'm just pointing out some of the most important development. 66. First soft landing on the moon took place in 1966. Not with the humans, only the object landing. It was Luna 9, right? The Soviet Union's Luna 9 made the first soft landing on the moon in 1966. And of course, it is also a great achievement. It's a great achievement because actually soft landing is not that easy on the celestial bodies. You know, India could able to do this only 2 years back. Remember, we could able to do it only 2 years back with the Chandrayaan 3, right? The soft landing on the moon, which was done by the Soviet Union in 1966. One of the greatest achievements at that time, right? Then 69, Again, all of you must know about it.
The Apollo 11.
Apollo 11. Apollo 11. So Armstrong and Aldrin landed on the moon. Yes. There are debates about the lunar landing, but whatever it may be, on record, yes. Is there any question? Oh, okay. All right. So there are debates about the lunar landing. Did they actually land on the moon, or did they take any photograph from Antarctic? That's all actually debates. But whatever it may be, on record, it is mentioned that they have landed. Not just that, between 1969 and 1972, there have been total 6 landings, including Apollo 11. There have been 6 landings: Apollo 11, 12, 14, 15, 16, 17. So all of them have landed, and every time 2 astronauts have landed on the moon. So 12 people overall have landed on the moon is the record as of now. After these achievements, you can find that private entities started to show interest in the space activities. If you look into 1980s, right, late 1980s and all, private investment started. When I'm telling private investment, it is not like the current era private activities. I'm telling you about the private players cooperating with the state agency for carrying on some activities, financing it, and then ultimately getting some benefit out of that. So that's how it started to come in the later part of 1980s and 1990s. But now, if you look into the current scenario, private players are the predominant players now. They have started to take over even the state ventures, and most of the commercial activities are entirely carried on by the private players at present. So that's how you can find a kind of a complete shift from the state-oriented space activities to private sector-oriented space activities in the modern period of the time. So this is how the journey took place from 1957 onwards. Now, when the space race began between US and USSR, in terms of the legal aspects, there were 2 questions, 2 important questions. One was, how do you define and demarcate the outer space? Right? Somebody wrote in the chat box saying that Kármán line is the distinction. Of course, it is debated, right? Not proper, right? One is the definition and demarcation. Second was about the applicable law. What is the law applicable? Definition and demarcation was attempted because, as I told just before, laws which are applicable to the aviation are completely different from the laws applicable to the space. So there was a requirement of finding out at what altitude aviation law is applicable, or up to what altitude the aviation law is applicable, above which the space law is applicable. So how exactly to look into that was the major reason why the definition and the demarcation was attempted. Different theories came up. There were theories like, say, theory of satellite orbit, the lowest the orbit wherein actually the satellite can revolve around the Earth would be the starting point of outer space. Some spoke about biological theory, some spoke about atmospheric theory, gravitational force theory, right? So until that height wherein the gravitational force exists to pull back the object shall be the airspace, and remaining should be the outer space. Like that, a different kind of theories cropped up. Different kind of theories cropped up, including the Kármán line theory. But none of them have been successful in terms of demarcating the outer space from the airspace. There were one or other problems. With each theory, there were one or other problem. Like, say, for example, if you take gravitational force theory, there is no abrupt end to the Earth's gravitational force at any altitude. Right? At 100 kilometers or at 80 kilometers, it is not that actually gravitational force is ending. It's not like that. Even your geostationary orbit, which is 35,800 kilometers above the Earth's surface, has the gravitational phenomenon. Earth gravitational phenomenon. Right? So that's why gravitational theory did not succeed. Theory of satellite orbit. Again, it depends on technology. Right? Earlier, the lowest orbit could have been 300 kilometers above the Earth's surface, not below that. It could have decayed down and fallen back to the atmosphere. But now, with the development of technology, it has become possible to put it at a lower altitude. So that is why even the theory of the satellite orbit does not hold good. So that's why at the international level, all debates have resulted in the conclusion that we will not be deciding what is the beginning point of outer space. Right? There is no formula to decide that, and there is no actually. And even another thing which you need to keep in mind is that it is not possible to demarcate like the law of the sea. In law of the sea, you have specific demarcation. Your territorial sea up to 12 nautical miles. And you have exclusive economic zone up to 200 nautical miles, not more than that. Like that, actually, you have specific limit. So why can't we apply that? Why can't we say that actually, say 100 kilometers above the surface is airspace, above that is the outer space? Why don't we bluntly do that? Any answer?
But sir, isn't there the Kármán line? That's the distinction.
Again, there is a problem. Kármán line, when Kármán started initially, he said 87 kilometers. That is the reason why NASA is also having the definition of 87 kilometers as the starting point of outer space. Then Kármán himself disputed his argument. He said 100 kilometers, right? And thereafterwards, Kármán again disagreed at a later point in time after the theory has been proposed, saying that it differs on the basis of the shape, size, and the velocity of the object. Go through the Kármán line theory, what exactly he proposes actually, right? So, so he himself has disputed it. But whatever it may be, some states basically consider that 100 kilometers should be the starting point, but NASA says 87 kilometers on the basis of the previous Kármán line's argument, right? So therefore, there are problems with every theory in terms of the starting point of the outer space. Now, as I said, 100 kilometers, why can't you accept? Any problem?
Yes, sir, because the surface of the moon, surface of the earth is not even at every point. Some, like we calculate it on sea level. So we can say if we consider it as 100 kilometers, so from mountain regions, 100 kilometers would be much higher.
Correct. Some places it may be less. If you consider 100 kilometers from the mean sea level, that's what actually usually been done. So if you consider like that, what is the problem? Ishita?
Sir, I think Kármán line is more of a spatialist approach, but if we go by the functionalist approach, then there could be a strict delimitation line between airspace and outer space. For example, if a vehicle...
No, functionalist approach is based on what? It is based on function of an object, saying that up to what altitude the aircraft can fly shall be the airspace, above that shall be the outer space. That's what it basically speaks of, isn't it?
Yes.
Look into the function of the object. On that basis, you are going to determine the airspace and outer space. It is not possible because with the development in technology, there is a possibility that the aircraft can get the aerodynamic elevation at a higher altitude. Similarly, the space objects can get actually the requisite centrifugal force for orbiting around the Earth at a lower altitude. Right? Functional approach would also fail in that sense. That would also fail in that sense. So that is why. And 100 kilometers, why 100 kilometers or plain line is not acceptable? Yeah. Yeah, Mr. Sanjay, yes, please. You have raised your hand. Is there any answer?
So I wanted to ask something.
Am I
Yes.
audible?
Okay.
Am I audible?
Now you are audible. Yes, please, please.
Yeah, just you mentioned that in future may happen, the technology when the planes will go there. But it already happened in 60 or 64 somewhere when the American pilot went to, all of a sudden to the outer space. And you can find the document in the Google as well. So we cannot define, where the planes can go in the future. It's already happened.
Absolutely, absolutely. A good point. It's a good point.
Yeah.
Yes, because with the technological development, what would happen is that the aircraft would get the aerodynamic elevation at a very high altitude. Even if the atmosphere is very less, still it may be capable of actually getting the aerodynamic elevation at a very high altitude. Then, if you say 100 kilometers is the line, and aircraft is flying at actually 120 kilometers, you will end up in applying space law for aircraft. Right? I have already told you that they are completely distinct and contradictory. So you can't apply a wrong law for a particular object. Similarly, there might also be a possibility that the outer space coming down with the satellites actually being orbiting at a lower level. Say if you say 150 kilometers or 200 kilometers shall be the line of distinction. The space objects will come back to 120. Then you are going to apply the aviation law, which is again a wrong application. That is why it is not possible to bluntly distinguish the airspace from outer space with a particular altitude. Unlike in sea, because in sea you have only one object, the ship which is moving therein, right? It changes the jurisdiction. But in airspace, it is not like that. Airspace and outer space, it's not like that. You have two distinct objects having different functionalities. And if you demarcate on the basis of altitude, you will apply the wrong law to a particular object. This has also been realized by the UN COPUS, United Nations Committee on the Peaceful Uses of the Outer Space. Therefore, the member states have come to the conclusion that this has to be done on case-by-case basis. There is no requirement of distinguishing airspace from outer space. Rather, you have to find out which law is applicable to a particular object in a particular case. For that, do it on case-by-case basis. Whatever court or whatever adjudicating authority is looking into the matter, if any mishap occurs at 120 kilometers, let it first look into the nature of the object. Is it flying with the aerodynamic elevation, or is it actually moving upward with the help of a rocket or anything else? What is it? Or centrifugal force? What is it using? Look into the nature of the people. Are they actually, say, moving from one country to another country like a passenger, right, in the aircraft? Or are they one who are in the space suit and all actually for a travel to the space? How are they? Maybe look into the registration. Has it been registered as an aircraft or a space object? Like, so all these factors taken together, the adjudicating authority should come to the logical conclusion instead of demarcating the airspace and outer space bluntly in any manner, which is very much futile, has been actually a kind of a decision taken at the UN COPUS. Yes, Kunal? Sorry, Kaushal, right? Yeah, Kaushal.
Sir, I have got to know that there are some organizations who don't, they are having 80 kilometers as a boundary. Like there's a federation called Federation Aeronautic International. So they use 80 kilometers as their boundary. So there is a kind of a, what do you call, that some don't follow the Kremlin line.
No, see, Kármán line is also not the standard, as I told you, right? The Kármán line also is not a standard. So that's the reason why different, actually, the bodies are having different kind of say, criteria for the purpose of determination of the beginning point of outer space. If I have to tell you, one of the biggest problems which have cropped up in the recent past has been out of the private space tourism. Private space tourism. You know who was the first private space tourist or first private space tourist vehicle which entered into the space?
So I think it was a German company, Auto.
No.
Was it Katy Perry and the team just went recently?
No. 2021. So when the private space tourism started, Virgin Galactic, I can see. Yeah, Dennis Tito was not with the private space tourism. It was with the public vehicle only. Dennis Tito was the first space tourist, correct? But it was with the Russian US vehicle. It's not with actually the private players carrying out. Yes, Virgin Galactic. And
Richard Branson and team?
Richard Branson himself entered there. The CEO of the company himself went there. Up to what altitude he reached? Any idea? Close to 87 kilometers. He reached close to 87 kilometers and he came back. Right? Soon afterwards, even Blue Origin did that. Right? Jeff Bezos went to 106 kilometers or something like that. Now the question is with respect to Richard Branson's flight. Was he in space? Did he enter space? Or was he still in airspace? That was the biggest debate. This is important because if something has happened at 87 kilometers above the Earth's surface, some mishap occurred, some kind of actually the wrong has been committed. Immediately next question is that what law are you going to apply? Are you going to apply air law or are you going to apply space law? Got it? Which law are you going to apply? That itself would be debatable.
Yes.
Now, NASA says 87 kilometers is the beginning point of space. As per NASA's definition, he is in space. As per some institution which you have referred to, 80 kilometers, he was in space. But then, if you look at the Australian legislation, or in many other countries, they all find that 100 kilometers shall be the minimum distance. They make a reference to 100 kilometers. Even though they don't accept it as the blunt line of distinction, still they say that their laws are applicable for an activity beyond 100 kilometers. That's how they mention it. Most of them. They're space laws. Going by this, Richard Branson was not in space. He was in airspace. Right? So that is why one of the biggest problems posed by the private space activities at present is which law you're going to apply. And moreover, another thing which you keep in mind is that most of the vehicles which are used for the space tourism are the aerospace vehicles. Aerospace vehicles. They have the horizontal takeoff just like an aircraft, right? They will fly in the atmosphere like an aircraft and then enter into the orbit and revolve around the Earth like a space object. They are aerospace. They are not just actually say either aircraft or space object straight away. They are having both combinations. So precisely because of that reason, private space activities are posing a lot of private space tourism is posing a lot of challenge in terms of the application of the law concerned. It's better if you can ask the question. I will not be able to follow the questions in the chat box, so don't type it. If you have any question, you can ask us directly. Yeah, and soon after asking, also mute yourself so that actually there is no intervention. Is there any question? Somebody was chatting.
So, what is the Indian law said about this?
No, India doesn't have a national space legislation till today. So I have been part of actually the drafting committee. Till today, it has not come up, and it's an unfortunate the situation. We are having only the 2023 policy, right? And it is not mentioning the line of distinction. It's not mentioning anything about that. Rather, it is simply saying for a space activity, you need to take license from in space. Right? You need to take license, and in space has also come up with the NGP norms, guidelines, and procedures for the purpose of granting the licenses in 2024. Right? Unfortunately, we don't have a space law, which should have been there. That should have been the starting point, and then the guidelines or maybe the bylaws should have come up. Unfortunately, it has not happened, and this year it is expected. Let's see this year if it conceptualizes at least.
So, do we have an airspace law then?
Aviation, yes, we are having multiple laws. It is not actually one single law.
Yeah, but different planes having different.
No, see, aviation law on liability, you have actually the Carriage by Air Act. With respect to liability, you are having that. With respect to say hijacking, you have Anti-Hijacking Act. With respect to Tokyo Convention, you have the Tokyo Convention Act. Right? With respect to the Montreal Convention 1971, those which would threaten the aviation security, you have an act in the national level. Right? And then you have got recently the amendment of the Air Act and the Aircraft Act and Aircraft Rules. Right? Now it is Bharatiya Vayuyana Adhiniyam. Right? This has come up in the recent past. So that's how we are having different laws with respect to the aviation sector. But space sector, as of now, we are still looking forward for a specific legislation. Right? Yes. Gaurav?
Sir, I have a follow-up question. My question is, why is the government reluctant to bring up an act for this? Because in 2017, I guess we had one national space bill, and that didn't see the light of the day till date. And so why is there reluctance when the activities are going on with full speed?
All right. So this cannot be part of the recording, to be very precise, since I'm also part of the drafting committee, one of the 4 members. Yeah. I have been involved with this since at least 2003. Right? There have been discussions with respect to the national space legislation. At that time, ISRO had one of the great scientists who had also the knowledge of law to a greater extent. Right? So the scientific secretary at that time, Dr. Rajiv Lochan, he was supposed to be the next chairman of the ISRO at that time. Unfortunately, he passed away in an accident. So he was very keen with respect to having the law. So we were having the discussions at that time. Unfortunately, after his death, there was not much development. 2011, they called for a meeting. Some 8 of us were actually called with respect to giving input with respect to the national legislation. We gave our input, and I also proposed for drafting a law from our side because it's a law. Law has to be drafted by the lawyers, not by the scientists. One of the biggest problems which they felt was that ISRO's discretion might be curtailed by virtue of this law. That was the biggest skepticism which they had, and therefore they wanted to do it on their own. They drafted something after 2 years. Actually, it has been circulated. It was terrible draft because if the scientist is drafting a law, how it would be. So I had a lot of comments on that. I just actually made all those comments, and then it was sent back. Actually, even to the Department of Space also, it has been sent across. So there was no much development there afterwards. 2017, suddenly this draft appeared in public, right? So without any consultation with any one of us, so it appeared in public. I wrote a critique on that. It is also available in the New Space Journal, one of the Scopus listed journal actually. So I have given the detailed critique of why the 2017 draft is a terrible draft for the India. 2022, once again, actually they woke up, and then 4 of us were made as actually part of the drafting committee. We drafted it. It has been sent across to the PM's office. We are still waiting for the further development on this. So this is what is actually the current development, and I can't comment much more on that since it was more in terms of confidential work, right? I can't give you the substance.
Thank you, sir. Yeah, this answers my question. Thank you, sir.
Yeah, but I don't know which kind of draft is going to come now. This year it is supposed to come because it is 2022 that we drafted. Now it might have got so much of wear and tear. So don't blame me if at all there is something which is terribly wrong in that, right? So yeah.
Thank you, sir.
So I think so definition and demarcation is still a question. That's what I just wanted to tell you. But current agreement is that it has to be decided on case-by-case the basis, and whether you have to apply aviation law or space law, the competent authority has to decide. Next, another important question which cropped up along with the space race has been the question of applicable law. What is the applicable law in space? Until that time, say 1957 and all, nobody thought entry into the space. No law was developed. So, is it a situation that the law of a particular state is applicable in space, depending on whoever is carrying on the activity, or public international law is applicable, right? Being international, so can it be applicable to the space, or is it a situation of no law in space? You can go and do whatever you would like to do. So this is a kind of a debate which cropped up after the space race began in the 1950s. What came to the rescue and the immediate development has been the United Nations. Right? It was the United Nations, and especially the United Nations General Assembly started passing the resolutions. Right? So at the international level, it started to pass the resolution with respect to the space activities. After this, you can find 3 stages of development of space law. There were 3 stages of development of space law. First has been the UNGA resolutions. 1958 onwards, they were passing series of resolutions, and even today also they are passing the resolutions. I would like to say that the first stage of development has been the soft law development, because UN General Assembly resolutions are not binding. They're not binding. They're just recommendatory in nature. Unless and until it is stipulated, they are just recommendatory in nature. So first stage has been soft law. Then states realized that we need to have something binding in the international level. The hard law, treaties. So the consequence was the development of the second stage, 1967 to 1979. 1967 to 1979, you can find 5 treaties being entered therein. Outer Space Treaty 1967, which is called as the Magna Carta, right? It's called as the Magna Carta of the space law. Then you have the Rescue Agreement of 1968, with respect to the rescue of astronauts and personnel. Liability Convention of 1972, fixation of liability. Registration Convention 1975, right? Registration Convention. And finally, the Moon Agreement. Moon Agreement 1979. So that was the 5th major international treaty which has been entered into. Unfortunately, the Moon Agreement has not been very successful. It has not been very successful, and you can find that there are only 17 states who have ratified the Moon Agreement. right? The Moon Agreement is primarily applicable to the Moon and other celestial bodies, whatever other celestial bodies are there. Not to the space, not to the space per se, rather to the Moon and other celestial bodies. But it has only 17 ratifications, and majority of them are not even spacefaring nations. Except Australia and Netherlands, you don't find any major country being part of the Moon Agreement. Right? And Australia and Netherlands are also having very limited activity in the Moon or other celestial bodies. Their activity is predominantly in space, not on the Moon and other celestial bodies. That is why practical application of the Moon Agreement itself is in question. How practically it is, of course, for the parties to the treaty, it is applicable by virtue of the Pacta Sunt Servanda. Right? It's applicable to them. But who are the parties? Parties are not the major spacefaring nations. So practically, its effect is almost near zero. Right? So that's how the Moon Agreement has failed to a greater extent in terms of getting the global ratification. After the failure of the Moon Agreement, you don't find any major treaty being entered. The second stage of the development of hard law almost stopped, and a kind of a third stage started subsequently. Because there was a debate on many other aspects of the space. They wanted to have treaties, but the states were not agreeing for it, because in the UN Corpus level, there is a requirement of a consensus for passing any resolution. Somebody's mic is on, I think. Can you switch it off? It's interfering in between. Yeah, okay. I think no, it's better. Yeah. All right. So there were many proposals with respect to different aspects of the space activities for the purpose of having a treaty. But unfortunately, the states were not agreeing. And in UN Corpus, there was a requirement of consensus. All states need to accept for the purpose of passing a resolution on a treaty. By virtue of this consensus rule, no treaty was forthcoming. Ultimately, a third stage of development took place. Again, these are UN General Assembly resolutions, not binding. However, in one of my papers, I have analyzed this as a kind of a midway approach. Midway approach. To be very precise, there is no midway between hard law and soft law. Hard law is something which is binding, enforceable. Soft law, non-enforceable. That's it. But I mentioned it as a kind of a midway because the three instruments which came into existence in this third stage, they have been given a kind of an elevated status by the states. Right? Even though they are not binding, they were not agreed to be binding. But what they said is that to a greatest extent possible, whenever it is possible, we are adhering to it. And they did it. In practical terms also, they adhered to those set of principles. There were three set of principles. One was on direct television broadcasting. Set of principles regarding the direct television broadcasting. All of them are passed in the UN General Assembly. Right? UN General Assembly. So 1982, direct television broadcasting principles. 1986, set of principles regarding the remote sensing of Earth from outer space. Right? Remote sensing of Earth from outer space. Because what happens is that if the territory of one state is sensed by another country, and then subsequently data is being shared to some other country, there is a possibility of misuses. So therefore, set of principles on the remote sensing came into existence in 1986. Third set of principle has been with respect to the use of NPS in outer space. What is this NPS? Any idea? Yes, Anubhav?
So I'm not really sure, but I believe it is something to do with nuclear powers.
Absolutely. It is nuclear power source. NPS is nuclear power source. Right? 1992, you have got a set of principles on the nuclear power sources. Because satellites by then were also using nuclear power sources for the long-range missions. Nuclear power sources can provide constant energy for a long period of time. So precisely because of that reason, satellites were using the nuclear power sources. But the problem is that if at all these satellites fall onto the Earth, right, and scattered over the territory, you'll be having the radiological or nuclear contamination. Right? There will be problems. So precisely because of that reason, in order to have some safety measures, a set of principle on the nuclear power source was also entered into in 1992. So that's how the third state predominantly contained these three set of principles. There was also a 1996 declaration, benefits declaration, and even in 2003 also there was another declaration. But they were not the major instruments. You don't find actually they having any major influence at the global level, right? So that's how three stages of development of space law took place, and it almost predominantly ended by the end of 20th century. At 21st century, you don't find major development in terms of the treaties. Though there is a lot of debate on a lot of issues, still you don't find any major developments. Yes, Anubhav?
So would the withdrawal of Russia from the nuclear treaty in space be considered a major development?
Not exactly. Which nuclear treaty you are saying?
The armament of nuclear bombs in space.
There is no such treaty. There is only, say, partial test ban treaty, PTBT, and the other one is the CTBT. CTBT has not been accepted by the countries.
Okay.
Yeah.
Sorry, sir.
The PTBT is something which basically prohibits the testing of nuclear weapons in outer space. That only prohibits the testing of the weapons. Right? Yes. Atharva?
Sir, I had a question regarding liability. Many companies and countries are proposing to dump trash into the space. So who will be held liable for the dumping?
I'll come to that. I'll come to that in the later slides. Right? I'll come to that.
Sorry.
Gaurav? I'm still with the development, right? I'll come to the principles which are there in the treaties and all. I'll come to that, right? Yes. Gaurav?
Okay. So my question is that as you told us that there are three stages of development of the space law. First one was a soft law development.
Correct.
Third one you called a midway approach.
Correct.
So, but sir, again, being this also UN resolutions, how can we term this as a midway approach and not again a soft law approach?
I completely agree with you. I started with that. It is again a soft law only. It is not hard law, not enforceable. But I mentioned it as a midway because the states have adhered to these principles in practical terms. They gave a kind of an elevated status because of the self-interest. If you don't adhere to this, there will be more and more conflicts in space, right? Like say NPS, use of nuclear power as the sources. If you do it randomly, then everyone would be threatened out of it, isn't it? So that is why, even though it's a soft law in the UNGA being accepted, still states in practical terms have given an elevated status to them, right? That's why I said midway, but still soft law, right?
Sir, my question is regarding the fact that in recent developments, we are facing a lot of cyber spoofing and jamming of the satellite communications. So, which affects the aviation industry, the maritime industry as a whole. And now, what do you think could be the proper approach for that?
I will answer this after going to the remaining, right? I'll go with content and then I'll answer this, right? You can ask me when I'm discussing about the military aspects. At that time, you can ask this question, right? So you are clear about actually the development, right? The three stages of development. Now, as Gaurav has rightly pointed out, what is binding in the international level for us is only 5 treaties. That to the 5th one, only 17 countries, right? Remaining 4, majority have accepted 100 or even outer space treaty is more popular. And it is also considered to be part of customary international law. Most of those principles have been accepted by everyone without any kind of objection, right? So, and all spacefaring nations are part of that. So that's why it's considered to be part of customary international law as well. My focus now onward would be more in terms of outer space treaties principles. And then even actually how the other treaties are also basically telling about the specific aspects. First thing, which one need to understand about space law is that it is distinct from our earthly laws. It is not based on monopoly rights. It is not based on individual gain. Historically, space law has always advocated for the common rights. Common rights. common rights does not mean that prohibition on any activity. Please don't come to the conclusion that no, you can't do anything in space. It belongs to everyone. Nobody can do anything. No, not like that. But when you are carrying on any activity, you need to respect the right of everyone, since it belongs to everyone in common, is the argument. Right? So the outer space or celestial bodies, their resources, they are all charity of the nature. Right? They are the charity of the nature. This charity of the nature belongs to everyone is the ideology behind the space law. Right? And in fact, if you look into the time when the space law developments were happening, most of the countries were liberated from their colonial powers after the Second World War. But they were devastated. Right? Politically and economically, they were completely devastated because of actually, say, number one, the previous administration has given up. They have left to their own the countries. Consequently, the new administration was supposed to be established therein. And in terms of economic aspects, those colonial powers have looted these colonies. Resources were all taken off. So precisely because of that reason, they had a lot of economic and political problems when the decolonization process took place. And the space law was developing in the same juncture. So these majority of the countries who have come out of the clutches of the colonial powers, they expected that the problem of colonization which they have evidenced should not recur in outer space. It should not recur in outer space or celestial bodies. If it recurs, then again, see, these colonial powers would conquer all those other places. They will start extorting the resources. Exploitation again. So the colonial problems, which has been actually understood by the international community, was one of the major reasons for advocating for the common rights. That's one thing. Second, even US and USSR agreed for this common rights at that time. Do you know why? What could have been the reason? Why US and USSR could have agreed? Yes, Atharva?
So, because they both were only in space research and space activity.
I couldn't hear you properly.
Sir, US and USSR were the only two organizations which were dominant in the space research and space related activities during that time.
Correct, but why did they agree for the common rights? Why didn't they say that actually, okay, we will exploit, we will go there and get everything? Gaurav?
Sir, maybe because of space diplomacy, because they wanted to take all the countries into confidence so that they could properly exploit all the resources.
Historically, they never did that. And that too, US is never a country to do such kind of a thing. Now, to be very precise, both US and USSR were skeptical about each other's development. They were also not very sure that who is going to actually win this race. Suppose if actually it is to be allowed, right? And anyone can go there and exploit everything and the individual rights can be established. Both US and USSR were also not very sure whether it is US which is going to win the race or USSR which is going to win the race. Right? By virtue of all these things, everyone, including US and USSR, agreed for the common rights principles. And these common rights principles, you can find it reiterated in the Outer Space Treaty in many places. Article 1 itself says that exploration and use of the outer space, including the moon and other celestial bodies, shall be for the benefit and interest of all countries and province of all mankind. That's what it basically says. Article 1, first paragraph specifically says it shall be the province of all mankind. Right? Activity should be for the benefit and interest of all, irrespective of their economic the development. And it shall be the province of all mankind. What is province of all mankind? You might not have a definition of it. But if you look into the historical development of Outer Space Treaty, the drafters who gave the feedback with respect to that, and the scholars' argument of 1960s and 1970s, it is very clear that province of all mankind is an extension of res communis regime. It's an extension of res communis. What is res communis?
So property of everyone.
Instead of property, it is better to use it is something belonging to everyone. because property would have a right of disposal. In res communis, there is no right of disposal. Right? That's why it's said to be belonging to everyone, and everyone can make use of it, but nobody can claim the individual right. Everyone can make use of it, like say high seas. Everyone can make use of high seas. There is no restriction on that. But nobody can say that this part of high seas belongs to me, that part belongs to other. No, that is not permissible. Or if I have to give a parallel in the domestic level, certain common property resources, common park, common pasturage, right? Common pasturage. Anyone who has a cow can go and graze the cow therein, isn't it? Right? So that belongs to everyone, and everyone can make use of it. Nobody can claim the private rights. However, in res communis, there is no concept of benefit sharing. Whoever is having the cow can go and graze the cow in the common pasturage. Others cannot object to that. But those who are not having the cow cannot say that it also belongs to me, therefore give me the benefit, share the benefit with me. They can't do that, right? So therefore, in res communis, one of the major problems is absence of benefit sharing. That is why the drafters of Outer Space Treaty, they use the term province of all mankind. Exploration and use shall be the province of all mankind, which was intended to have a kind of a voluntary sharing of benefits. It's not telling about compulsory sharing, but since you are taking from actually the common resources, at least you need to go for a voluntary sharing of the benefit over and above the res communist regime. That was the ideology behind the province of all mankind. And this ideology was attempted to be furthered by the Common Heritage of Mankind principle, CHM, Common Heritage of Mankind. Please don't tell anyone that outer space is common heritage of mankind. It has never been agreed. Outer Space Treaty never mentions about the common heritage of mankind. It is only the Moon Agreement, Article 11, which speaks about the principle of common heritage of mankind. Okay, the Moon Agreement. Therefore, it is Moon, other celestial bodies, their resources are said to be the common heritage of mankind, not the outer space per se. Moreover, as I already told you, Moon Agreement has not been signed and ratified by many, very few countries. So the common heritage of mankind principle is applicable only for those countries who have ratified it, not for others. Not for others. And it has also not attained the status of customary international law. Please keep in mind. There are arguments, but it has not attained the status of customary international law. States have got reservations. So precisely because of that reason, common heritage of mankind is not something which has got a strong footing in space law. However, province of all mankind is an adequate reflection of the common rights principle applicable in space. Right? And even it speaks about benefit and interest of all countries. Article 1 mentions about it. So therefore, common rights is advocated in the Outer Space Treaty itself. Second, Article 2 mentions about the principle of national non-appropriation. If you can go through Article 2, it says that outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, use or occupation, or by any other means. Right? It is not subject to the national appropriation by claim of sovereignty, by use or occupation, or by any other means. There is no possibility of national appropriation. Now, there are two questions which arise, which I will address later. Of course, let me tell you right now. One, it says national non-appropriation is prohibited. What about individual? Can a private entity appropriate it? Number one. Number two, is there a prohibition only on the land property rights, or is there also a prohibition in terms of the mining rights? Right? This is the second thing. Both of them I will address at a later point in time. Right? So, but please keep in mind that Article 2 prohibits the national appropriation by claim of sovereignty, use or occupation, or by any other means. Then, Article 1 itself again provides the freedom of exploration, use, and scientific investigation. Article 1, again, exploration, use, and scientific investigation. It provides the freedom to explore. One can understand going there and exploring something. It provides the freedom of use. Does this provide the freedom of exploitation? Exploitation? Yes, Neha?
So if the parameters of use are not defined, the four walls of use are not defined, can tremble on to exploitation.
Very good answer. Very good answer. Based on the argument of the Western scholars. But let me rebut it. It was not the intention of the drafters. Intention of the drafters of the Outer Space Treaty to use the term use has been to confine only, for example, using the moon surface as a platform for launching to some other celestial bodies, or using the Earth orbit for placing your satellite. That was the understanding of the use. Most of the Western scholars who are supporting the mining or maybe say land property rights, etc., they are arguing that exploitation is inherent under use. When you are using the resources, we are utilizing the resources. Isn't that a use? That is an argument which they are putting forward. And if it is used, it is permissible under Outer Space Treaty. It speaks about freedom of use. So you exploit the resources, that is a use within the ambit of the freedom. That's the argument which they try to put forward. It's a wrong argument. Drafters categorically had a distinction between the use and exploitation. Even in the negotiating history, you can find that. More than that, you can also substantiate this with the Moon Agreement. Article 11 of the Moon Agreement, 11.4 and 11.5. If you can go through it, if you have, you have the internet connection, so you can also go through that. Article 11.4 and Article 11.5. Article 11.4 reproduces the same freedom of exploration and use. It says that every country has got the freedom of exploration and use in the moon and other celestial bodies. But then 11.5 says that 11.5 is the first provision to mention about exploitation. It mentions separately about exploitation and says that when the exploitation becomes feasible on the moon or other celestial bodies, you need to establish an international regime to regulate it. There is no freedom. Exploitation is subject to the international regime, whereas exploration and use is subject to the freedom of the countries. Right? So therefore, the drafters made a clear-cut distinction between the use and exploitation. Argument of the Western scholars are not something to be accepted. Right? Outer Space Treaty provides only the freedom of use and also scientific investigation. You can also go ahead and have the scientific investigation. And if anything is required for scientific investigation, you can use it. That's it. Not more than that. It's not exploitation. Right? So freedom is confined only to the exploration, use, and scientific investigation, not exploitation. That's not subject to the freedom. Next, principle of cooperation between the states, which runs like a golden thread throughout the space treaties. Not just Outer Space Treaty, all 5 treaties. You can find it like a golden thread. In Outer Space Treaty, you have Article 1, Article 3, 9, 10, 11, 12. All of them speaking about cooperation in one or other aspect. Next, you have the Rescue Agreement, which speaks about rescuing of the astronaut or personnel and returning them back to the launching authority. How is this possible without the cooperation between the state of unintended landing and the launching authority? There is a requirement of cooperation between the two. Right? So that's how cooperation is the mantra in the Rescue Agreement. Liability Convention. People might ask me, why even in terms of liability, what cooperation? Liability is one state is liable to pay compensation to the other state. So how cooperation is working there? The Liability Convention incorporates cooperation in terms of dispute settlement. Because all dispute settlement under the Liability Convention is through the diplomatic consultation. Diplomatic consultation. And if the diplomatic consultation doesn't work, then the next step is to go for establishing a body called Claims Commission. Claims Commission. And this Claims Commission is to be established by the representative of a claimant state, another member by the victim state, and a third member jointly appointed by both of them together. Again, a body constituted with the cooperation of launching and the victim states. So that is how cooperation is the mantra, even in the liability convention. In registration, right, there's a requirement of double registration. State has to cooperate, register the space object in the national registry and in the UN registry. Moon Agreement, there are n number of provisions, just like the Outer Space Treaty, speaking about the cooperation between the countries. So that's how cooperation is a kind of an interest factor in the space treaties. Sneha, you have any question? You raised your hand in between.
Yes, sir. I just wanted to know that in the practical aspect of things, ideally, since space is nature's gift to all of us and to mankind, there should not be any, tensions between nations. There should be cooperation. But in practice, is there actually cooperation? Or is it viewed as a national, like a citizen national thing?
Very good question. Because actually, if you look in practical terms, it is all on the basis of the geopolitical the equations, right? It is not happening on the basis of the space treaties provisions. If you look into the arguments of Maureen Williams, that is the point which the scholar is saying is that as of now, the cooperation between the states has not attained the status of customary international law, right? Because if you look into the Outer Space Treaty, if you look into the Rescue Agreement, or if you look into the Registration Convention, specific nuances of the cooperation has not been mentioned anywhere. How do you need to cooperate, right? What kind of things you need to share during the process of cooperation? Those things are not mentioned in any of these provisions. That is why it has not become part of customary international law in practical terms. But then again, she is saying that it is moving in the direction of the cooperation or the customary international law. Why? Because with the increased space activities, every country or maybe the enterprises in every country is not in a position to take care of everything. Be it maybe the technological aspect, be it maybe the financing, because you need huge investment. From where the investments come, you need to get cooperation from others. So that's how what Maureen Williams is saying is that this is crystallizing into a kind of a customary international law. But the only thing is that it is self-evolving. We have to wait until actually it self-evolves and becomes a kind of a part of customary international law. Right? That's what is basically happening. Hope it answers the question. Right? Kaushal, sorry.
Yes, sir. Thank you.
Sir, I wanted to ask about this core principle, the cooperation between the states. So there is a growing concern about the space debris, we have come to know. And there is an authority also. But there are no clear guidelines like universally adopted by everyone.
Space debris has been a matter of debate soon after the Moon Agreement. If you look into the UN Corpus working, they had a draft of the separate treaty on the space debris, which has not been agreed even till today. And all other agencies who are working, right? So I think you may be referring to IADC. IADC is not actually having an authority over the states. It's only an agency which is trying to seek the cooperation in terms of the debris mitigation, right? Or even UN Corpus has come up with actually guidelines, debris mitigation guidelines, but they are not binding. They're not a treaty even till today. It's still going on. Cooperation is not forthcoming. And there is a reason for that. The reason is that Article 9 of the Outer Space Treaty is quite weak. I'll come back to that. I have a slide on Article 9 also. I'll come back to that. I will explain to you why that Article 9 is a problem in terms of debris mitigation. Right?
Thank you, sir.
Yes, yeah, Gaurav?
Sir, building on to question which Sneha has already asked, my question is that supposingly, and we know that China and North Korea are two countries. North Korea is not much into space race for now, but China is there in space race. So these countries are known for launching their vehicles or satellites without informing the world about them. And we do have principles in Outer Space Treaty as well that talks about that one needs to inform to the UN and to the world about their prospective launch and once the launch has taken place. So how does the international law address this?
Outer Space Treaty doesn't have any such provision. There is only provision in the registration convention, wherein you are supposed to register the space object after launching into the Earth orbit or beyond. Right? I'm supposed to discuss the registration convention also. Anyhow, you have asked the question, let me tell you. Problem with the registration convention is that there is no provision specifying the consequence of non-registration. There is no provision which specifies the consequence of non-registration. So automatically, these countries who are not registering or not informing to the international community have no sanction. Right? Because drafters at the time of drafting thought that there would be cooperation, everyone would be willing to give this information, and that's why the cooperation has been the basis of even the registration convention. They didn't include a provision saying that if you don't inform, then you have this consequence. They didn't include that. Right? So that's why it's a fallout of the failure of cooperation, to be very precise.
Yes, so there is just a follow-up question. That being the situation, isn't the space law actually very weak in this sense with regard to saving the mankind or something like that?
Absolutely. There are certain actually the areas wherein space law is very weak, right? But there are certain areas wherein it is quite strong to actually deal with the situations, like liability to a certain extent. In case of, I mean, I'm not telling that every part of that. I'll also discuss what concerns are still there in the liability. I will tell you. But whatever it may be, it is not a situation of no law. It is not a situation that you will do whatever you would like to do. Like what Trump is saying actually should be the authority at the global level. No, it is not like that. You have certain regulations, right? You have also certain loopholes. Loopholes are there in every law. It is not just in space law, right? And the lawyer's brain works in that itself. So how to make use of the loopholes, how to defend a party on the basis of those loopholes, that's what actually works, right? Okay.
Yes, thank you, sir.
The last principle is the astronauts as the envoys of the mankind. The astronauts who are going to the space are considered to be the envoys of the mankind. They are not just the representative of their own country, they are the representative of the whole mankind is the logic. Right? The US astronaut is not just the representative of US, right? He or she is the representative of the entire mankind. Indian representative, Chinese representative, or maybe Japanese. Why? Because of two reasons. One, initially, it was thought that there might also be life forms in other celestial bodies. Outer space or other celestial bodies might have the life forms. Whoever is going to the space or celestial bodies would interact with them on behalf of the mankind. On behalf of the mankind as a whole was the first ideology. That's one reason. But of course, we didn't find any such kind of a life forms for the interaction till the now. That's a different thing. Second reason, as I told you earlier, Article 1 of the Outer Space Treaty clearly saying that outer space activities shall be for the benefit and interest of all countries. So these astronauts who are going to the outer space are supposed to carry on any activity for the benefit and interest of all countries. That was the logic. So that is the very reason why we are having the principle called astronauts are the envoys of the mankind. And by virtue of that, you have got the rescue agreement, 1968 rescue agreement, which categorically says that you need to go and assist the astronaut and return them back to the launching authority in case of any kind of an unintended landing. In any country, wherever they would land, right? The concerned country has an obligation to go search, rescue, return them back to the launching authority. And rescue agreement uses a broader term. It not only uses the term astronaut, it uses the broader term personnel. Right? Personnel of the space object, right? Remember, they use the term personnel. Now the next question is that, is this wide enough to cover private space tourists? I told you, rescue agreement imposes an unconditional obligation. State of unintended land, it has to go, search, rescue, return the personnel. And personnel is wide enough to include astronauts also within the ambit of that. But now the question is that, is it wide enough to include even the private space tourists? Yes, Gaurav.
Sir, it was by mistake. Sorry, sir.
Okay, Anubhav wanted to say something.
So I believe, yes, no, it is not wide enough to include private space tourists because the personnel in term sense, it makes sense that they are agent of that particular country per se. So yeah, it won't be wide enough to cover private space tourists because they're on their own will, not because the government has sent them as a mission or something.
But is the government mission important? Because see,
But sir, isn't this on the basis of humanitarian ground somewhere? It's like a moral obligation. So
okay, good. I mean, good in terms of humanitarian grounds.
yeah.
All right. Let me just tell you two things. One, if you carefully look into the rescue agreement does not mention about the cost reimbursement whenever the personnel is rescued and returned back. No cost reimbursement. Whereas, if it's a space object, and if the space object has been actually say recovered and returned back to the launching authority, then there is cost reimbursement. Article 5.5 of the rescue agreement says that the cost has to be reimbursed to the state of unintended landing. So whoever has incurred the cost would be reimbursed. But with respect to personnel, there is no provision on cost reimbursement. Why? Because the rescue agreement goes by the logic that these personnel or astronaut plus personnel are the envoys of the mankind. That was the logic. So that is the reason why the state of unintended landing has to incur even the cost of the rescue and return, since they are representing everyone, including that state of unintended landing. Right? That is one thing. Second, let us draw a parallel of the definition of personnel from the aviation law. Whether passengers are included within the ambit of the personnel in the aviation law. Does aviation personnel include passengers?
No, sir.
No, right? That's a distinction which has been maintained in all the treaties. Personnel is only the crew members. Who are the personnel? Not the passengers. In the same fashion, if you apply the logic here, a private space tourist would not come within the ambit of the definition of the personnel. I agree with your argument of humanitarian grounds, yes, because even the rescue agreement, if you look into the preamble, the last sentence in the preamble says prompted by the sentiments of humanity. Right? It is prompted by the sentiment of humanity, but the crux of the rescue agreement is on the basis of the astronauts as envoys of the mankind. That has been mentioned from the top in the beginning itself. They are the envoys of the mankind, therefore they are entitled to the protection. That's what they basically mentioned. Right? It's only an argument based on prompted by sentiments of humanity, but substantive provisions of the rescue agreement does not support this as a kind of a legal obligation. It may be a moral obligation. You may say that it's a moral obligation to rescue them, but then it is not showcasing as a legal obligation, because at the end of the day, it does not provide for the cost reimbursement. That is why the off-late argument says that maybe in terms of the rescuing these space tourists or whosoever it may be, there is a requirement of developing a separate norm which should include the cost reimbursement to the state which basically rescues or returns. Because otherwise, imagine about a situation wherein so many space tourists going into the outer space and falling into a poor country in Africa, right? Falling into a poor country in Africa who doesn't even have sufficient resources for feeding their own people, right? The government going there, rescuing them, incurring the cost in terms of that, returning them back to the launching authority without getting a cost reimbursement doesn't make sense, right? They're already having problem in terms of feeding their own people, and now from the state exchequer spending more in terms of these activities would definitely be having a heavy toll on them. So that's the reason why the argument is that rescue agreement is not tailor-made for the purpose of rescuing the space tourists, private space tourists. Rather, you need to develop a new norm which should be based on the cost reimbursement. Yes, true.
Sir, I would like to add a point. When these conventions came into existence, at that point of time, space tourism was not much into consideration.
Yes.
It was only about the exploration for the developmental purpose, and only astronauts were considered. So I don't think that the inclusion of space tourists as in personal would be a right thing.
No, that is true. That is true. But at the same point in time, if you look at the Vienna Convention on Law of the Treaties, right, VCLT, it clearly says that the treaties need to be interpreted progressively.
Progressively, yes.
Right? It is not supposed to be interpreted as something static. Depending on the change in circumstances, you are also supposed to interpret that progressively. Right? But the only thing is that when you are interpreting that progressively, you should not go beyond the mandate completely.
Completely, yes.
You cannot actually completely reverse the mandate of it and then interpret it in such a manner that it's a progressive interpretation. So that is why limit is there, and that's why the argument is that you need to develop separate norms with respect to the space, private space.
Also, I would like to add one more point. Now, space tourism is something for your own relaxation or some kind of an entertainment.
Correct. Correct. It is not for benefit of mankind. That's the logic. Yeah, that's why I said astronauts are the invoice of the mankind. Personal might be helping the astronaut, but not actually private space tourism. Yes. You can read my own book on this. So it's a Rutledge book available in the market. I don't know whether you can have access. It's a book by Rutledge, Space Tourism. So all these issues are discussed in detail in that.
I've read one of your books, which is Emerging Trends on Space Law on the 50th anniversary of Outer Space Treaty.
No.
In which you are the editor.
Yeah, it's also, yes. Yeah, this is on space tourism, and of course, my chapter is available. It's available in the research gate. You can go through the research gate. You will also get that actually, right? So if you want to have access to it, you can go through it. First chapter. Right. So this is all about actually the issues in terms of astronauts as voice of the mankind. Next issue is about the responsibility and liability. International law makes the distinction between the state responsibility and international liability. In the domestic level, responsibility liability may be interchangeably used, but in international law, you have a distinction. Do you know what is that distinction? Distinction between the state responsibility and international liability. No idea? State responsibility arises out of a wrongful act. I think let me just go forward. We don't have much time actually, so let me just carry it forward. It arises out of a wrongful act. There is an international obligation. State breaches that international obligation. It is responsible for it. But on a contrary note, international liability arises out of a lawful activity. A lawful activity, when it results in damage to some other state, state is internationally liable to compensate. In simple terms, responsibility arises out of the wrongful act or fault or culpa, whereas liability arises out of
a lawful act.
It's
causing the damage. It arises out of damage. Right? It arises out of damage, not out of actually any wrongful act. Right? So what is important for liability is the damage. What is important for responsibility is the fault or the culpa. If I have to illustrate with the example, a state sponsoring terrorism, tell me, is it responsibility or liability?
Responsibility.
Absolutely, because that's a wrongful act. On a contrary note, if the oil is being shipped from one country to another country through the high seas, right? It is going through the high seas. Suddenly there is a shipwreck due to some natural calamity, and the oil spill results in damage in the coastal state, one of the coastal states. What happens?
It's a liability of the
state. Liability, because actually there is no wrongful act by the former state. There is a natural calamity. Consequent to that, the damage has been caused to the coastal state. So the state which is shipping the oil shall be liable to pay compensation, but it is not liable in any manner to stop that activity. In case of responsibility, there is a requirement of stopping the activity since there is a wrongful activity. But in liability, there is no requirement of stopping activity. Only adequate compensation need to be paid. So that's how the distinction is maintained between responsibility and liability. Outer Space Treaty also has got responsibility and liability separately under Article 6 and Article 7. Article 6 and Article 7. Article 6 speaks about responsibility of the appropriate state for all activities, including the private activities. It's not just confined to the state activity. It's a direct responsibility for any private activity carried on by their entities or within their territory. Please keep that in mind. In public international law, responsibility of the state arises only when the individual act is attributable to the state. That is maybe by either express or implied authorization by the state. In those circumstances, individual act is attributed. Otherwise, if two individuals are fighting, then state is not responsible for that. There is no responsibility. But whereas in space law, there is a direct responsibility for any activity carried on even by the private player. Please keep this distinction in mind, because most people argue that if a private entity is doing something, state is not responsible. That is incorrect, since Article 6 is clearly stating that it is the direct responsibility of the state. Added to that, Article 6 also says that there is a requirement of authorization and continuing supervision. Every private activity need to be authorized by the state, and those activities need to be continuously supervised by the state. A continuing supervision should be there from the part of the state. That is the reason why the national space legislation becomes important for authorizing the private activity as well as supervising them. Right? So that's about 6. Article 7, on the contrary note, speaks about the liability for damage, and the liability is on the launching state or launching states. It might be singular or plural. The launching state or launching states, because the definition of a launching state is wide enough to cover 4 categories of the states. There are 4 categories of the states. 1, the state which actually launches the satellite. 2nd, state which procures the launch. Right? Other country, somebody actually is launching from Indian facility, taking the help of the Indian people. So it is procurement of the launch. 3rd, state whose territory has been used for launch. 4th, state whose facility has been used for launch. One which launches, one which procures the launch, one whose territory is used, one whose facility is used, launch facility. So these are the 4 different categories of the states which can come within the ambit of the definition of launching state. You may ask me, what is the distinction between territory and facility? Isn't that actually the facility and territory would be same?
No, sir.
Sorry?
No, it's different, sir.
Why? Why it's different? Where do you find it different?
Like we can use the territory of France, and we can use the facility of some Italian company or some other country's facility.
Where is it located? Where is it located? Italian company's facility located where?
Yeah, if it's like located in France.
Then it's territory also. France is also, territory is France, facility is also in France.
Oh, okay, sir, then explain.
Sir, maybe space territory.
Sorry?
The space territory, sir.
No, because territory does not belong to any state therein. You can't say actually it belongs to any state. Sorry?
Space station or something like that belonging to some other entity.
In that circumstance also, territory does not belong to any state there, no? Right? So the
No,
out is space. Only facility is the same.
We can say that the who is controlling the activities of launching that spacecraft. So that company will also comes under the definition.
That comes under the first category. Who launches? Who launches?
Okay.
Right? So that's the first category.
Okay.
Now let me tell you, there is a facility in Kazakhstan which is owned by Russia. The Baikonur facility. Right? The Baikonur facility, which has been actually run by Russia. Now, let me tell you an example. Some Canadian entity takes the assistance of ISRO people for the purpose of launching it, actually, right? Canadian entity takes the assistance of ISRO people, and the launch takes place from the Baikonur facility. ISRO scientists are going there. From the Baikonur facility, they are launching a Canadian space object. In that circumstance, you are having the 4 states as the launching states. Canada is the launching state. Why?
Procures the launch.
Procures the launch. Absolutely right. Correct. They are procuring the launch. India is the launching state because it is launching. It's the scientists are involved in terms of the launch. So India is the launching state. Russia is the launching state because the facility belongs to them. And Kazakhstan is the
And
launch.
territory is the Kazakhstan.
Yeah, territory of Kazakhstan. So that is how 4 different states do come within the ambit of the definition of launching state here. And please keep in mind, within this, there might also be possibility of multiple. A launch facility, if it belongs to 20 different countries, you have European Space Agency launch facility, ESA launch facility, right? It belongs to all of them. All of them are launching states. All of them are launching states, right? And Article 7 of the Outer Space Treaty and the subsequent liability convention, which extends Article 7, speak about the liability of all these launching states.
That's a joint liability.
Joint and several liability. It is joint and several liability, similar to that of what you have in the partnership firm. It is not divided liability. It is a joint and several liability. Right? So that's what is mentioned under the liability, the convention. So as long as a particular state comes within the ambit of a definition of the launching state, it shall be liable to pay the compensation. Right? And Article 2 and Article 3 of the liability convention distinguishes between the absolute and fault-based liability. Absolute liability for any damage caused on the surface of the earth as well as to the aircraft in flight. So for both of them, absolute liability is applicable. But for circumstances wherein 2 or more space objects collide, maybe in airspace or maybe in outer space, not just in outer space. Many people would think that fault liability is applicable only in outer space. No, it's applicable also in airspace. But only thing is that it should be a collision between 2 or more space objects. If they collide in airspace or in outer space, whoever is at fault shall be liable to pay the compensation. Right? Whichever state is at the fault, whichever launching authority is at fault, shall be liable to pay the compensation to the others, the victim, the state. So that's how you have absolute and fault-based liability mentioned under Article 2 and 3, respectively. Now, one of the instances wherein the liability convention was tested has been Cosmos 954. Have you heard of this? Cosmos 954? Not really. No. It was the erstwhile Soviet Union satellite having a nuclear power source on board it, one of the earliest satellites to have the nuclear power source. Unfortunately, Soviet Union could not actually place it in the intended orbit, and it was decaying down. The orbit was decaying down slowly. It had entered into the atmosphere. It broke up into pieces. Usually that happens actually. So if atmospheric pressure cannot be withstood by the space object, then it gets into pieces. It broke up into pieces and fell over a large stretch of land in Canada.
Northern, yes.
Yes.
Northern Canada.
Northern Canada, yeah, because that's the place where actually it snows very heavily, right? So it fell over the large portion of the land. Now, these debris, of course, it's a nuclear power source, the satellite. They were capable of causing the radiological contamination, right? The radioactive materials were there. Precisely because of that reason, Canada had to carry on an operation which was called as Operation Morning Light for cleaning up these debris. Right? They had to go with the handheld detectors to find out actually where are these debris, because they are all covered with the snow. So they had to find it out, and then they had to neutralize the radioactive material by unearthing them, which carried on for almost 9 months in 2 cases. 9 months, a huge number of military personnel were involved, including the United States, the people. US also came forward and they carried on this operation. Ultimately, it resulted in an expenditure of 14 million Canadian dollars to Canada. 14 million Canadian dollars. They did not claim 14 million. They claimed only 6 million from USSR. They put forward a bill of 6 million Canadian dollars for the compensation. USSR simply said that I'm not liable to pay under the liability convention. Of course, it paid an ex gratia payment of 3 million. 3 million it paid as an ex gratia, but it did not take up liability under the liability convention, saying that there is no provision which fixes liability on me. Why? because of the restricted definition of the damage. There is a very restricted definition of damage. If you look under Article 1A, it defines damage under the convention. It says damage means loss of life or the personal injury, or alternatively, loss of or damage to the property belonging to the state, intergovernmental organization, or to any person. Damage or loss of property. Did that happen in this case? Did that happen?
No, sir.
Literally, it did not, because only some debris scattered over the certain territory. That's it, right? They were capable of causing the radiological contamination. Therefore, the preventive measure was taken to unearth them and neutralize them. That's it. And the definition did not include that. Right? It mentioned about only the actual damage which has happened, not about possible future damage and preventive measures being taken for that. Right? And this was one of the problems. And this problem was also there in the Nuclear Liability Convention. If you look into the 1970s Nuclear Liability Convention, had the same definition. Fortunately, in the Nuclear Liability Convention, amendments have taken place, and now even the precautionary measure costs are to be paid. It includes damage within the ambit of definition of damage. Unfortunately, the Liability Convention has not been amended. It has not been amended. We still have that restricted definition of damage, and that continues as a kind of a loophole in the convention. And even the dispute settlement mechanism, I told you, cooperation is required between the state. But then again, dispute settlement mechanism is very weak because of the reason that ultimate mechanism available is the claims commission, having one party from the victim state, one from the launching state, and together deciding the third person as the chairperson of the claims commission. But the claims commission's decision are binding only if the parties agree them in advance. It is similar to that of earlier arbitration. Previously, the arbitration was also like that. Now we have made it binding, right? So decisions are binding. But otherwise, earlier, unless the parties agree in advance, the decisions are not binding. The same logic is here. So consequently, states may fight it for 2 years or 3 years, ultimately without any binding remedy. Right? So that's the reason why the liability convention has got its own limitation. And I don't want to discuss further into that because you have a separate module on the liability. Aditya is going to take that. I saw that. So therefore, let me not venture into his domain too much. But still, there are problems. There are possible arguments for the lawyers. Lawyers can defend their case, their clients, whosoever it may be. So in future, it would be something which would be tested practically to a greater extent. Next, you have the registration convention. One of the shorter conventions, and registration is absolutely required for the purpose of identification of the space object. For identifying the space object, registration is very important. Say liability, I told you, launching state is liable. Unless and until you know which is the launching state, how will you fix the liability? Whom are you going to claim compensation? You'll not be able to, right? So precisely because of that reason, the transparency is required. Not just for this, even for jurisdiction, applicable law, even returning the object or the personnel, because it has to be returned to the launching state. So you need to know who is the launching state. For those purposes, registration convention speaks about double registration. One in the national registry under Article 2, and Article 3 and 4 speak about the registration in the UN registry. UN Secretary General maintains actually the international registry. You have to give the information. It will be registered in the international registry. Problem is that there is no sanction for non-registration. I have already told that. Right? And Article 6 also says that in a circumstance wherein even after these registration, or even because of the failure of the registration, if it is not possible to identify the space object, then the states which are having the tracking capability of the space objects must help the victim state in terms of identifying the space object. Those countries having the advanced tracking facilities must come forward to assist the victim state to identify to which state the space object belongs. Right? That's how Article 6 of the Registration Convention speaks about the requirement of the cooperation between the developed and the less developed country. So this is about the registration convention. I'm not very sure whether the time permits. There are 3 more slides, but I don't know whether I should go ahead or should I take the questions from you. There's only 5 minutes, 6 minutes left, I think. So, so I just wanted to cover about the sovereignty, property rights, and resource mining. Article 2 of the Outer Space Treaty. Article 2 does not permit all these things. National non-appropriation, as I told already, would also impose a prohibition on individual appropriation. And states are not permitted to do that. How can the private players can do it? That's a debate about the sovereignty, property rights, and resource mining. And then I wanted to tell you about the the next thing I wanted to tell you. It was about the protection of the space environment. We have Article 9, one of the weakest provisions in the Outer Space Treaty, speaking only about harmful contamination. It prohibits only the harmful contamination of the outer space. And those who say that, those who have created the debris, they argue that harmful contamination is a very, very narrow term. Debris creation is not prohibited. Because contamination is an intrinsic mixture of something. It's not, like say, for example, their argument, let me tell you their argument, how absurd it is, it's a different issue. They say debris is like a vehicle on the road. A vehicle on the road, it is rotating around the earth with a particular velocity. Anything coming in the way would be damaged by that, isn't it? Whether a vehicle on the road is harmful contamination? Absolutely not. Only the release of the or emission, whatever has been emitted from the vehicle, would be harmful contamination. Right? It's polluting the environment, it's contaminating the environment. So you can say it is harmful contamination. But a mere movement of the vehicle on the road is not harmful contamination. So debris is also moving like that. Unless it is releasing some substance into the outer space, it should not be actually harmful contamination, is their argument. Is their argument absurd, not in the spirit of the Outer Space Treaty, but unfortunately the provision has been drafted in that fashion. That's the biggest problem actually. And the last thing which I just wanted to discuss was the military aspect, Article 4 of the Outer Space Treaty. And I always say that there is nothing which is more shabbily drafted than Article 4 of the Outer Space Treaty. If you consider any treaty in the international level, to my understanding, no other provision has been more shabbily drafted than Article 4. Because Article 4, if you look into, first part prohibits the placement and orbiting of the nuclear weapons or any other kinds of weapons of mass destruction. It says these two being prohibited. There are 2 questions. 1, what about other weapons? What about other weapons? In the outer space, even a debris of 1 centimeter is capable of completely destroying a medium-sized satellite of 5 to 6 tons. Debris velocity is like that. 11,000 to 32,000 kilometers per hour is the speed. Right? It can destroy a satellite of 5 to 6 tons. Right? 1 centimeter debris. Debris. So you can imagine any conventional weapon being placed in outer space, how catastrophic it would be. But Article 4 mentions only weapon of mass destruction and nuclear weapon. Then,
it doesn't include the gases.
Let me just complete and take the question. Okay, just last couple of minutes left, so that's why let me just complete it. Second, it also mentions only about placement and orbiting. What about testing? What about testing? Now, currently, the anti-satellite missile testings have been conducted by many countries. They all try to justify by saying that Article 4, first paragraph does not prohibit it. Right? Even though recently some moratorium has been actually agreed upon, you can find that China, India, and Russia have not signed this the moratorium. It is only US which has been part of it. And China, Russia, and India are capable of doing that. We have already tested the ASAT. Right? Then, second part of Article 4 says that moon and other celestial bodies shall be exclusively used for peaceful purposes. Moon and other celestial bodies, let me repeat, shall be exclusively used for peaceful purposes. 2 issues. Number 1, why it does not mention outer space? It mentions moon and other celestial bodies. Somebody told me about cyber attack. Somebody told me about actually any other kind of the activities which are not tangible but still having some kind of a repercussion. Right? Why it has not been mentioned specifically therein? Then, it also says only peaceful purposes without definition. How do you interpret peaceful purposes? Initially, almost all countries agreed that peaceful means non-military, no military activity in outer space, right? That was the understanding. But then US subsequently made a U-turn, saying that peaceful does not mean non-military, it means non-aggressive. Non-aggressive, right? You can have a defensive military use. What is prohibited is only aggressive. And that's why they proposed earlier Star War program. And now Trump is also proposing what? Trump's proposal recently.
Golden Dome project.
Dome project, absolutely. Golden Dome project, wherein they will be having interceptors. They have the missiles which they are actually embedding in the outer space for intercepting the ballistic missiles. So they are also capable of destroying equally. If you put a nuclear warhead on that, they would also be resulting in destruction. Right? So precisely because of that reason, Article 4 is very, very shabbily drafted, and it is not capable of actually preventing different kind of military uses which the states are making at present. So these are the issues. And I mean, yeah, but unfortunately, I could not cover the last three in the detail. Yeah. So thank you. And if you have any question, you can ask me now. I know that I'm holding you back from the lunch. Yeah. Yes, please.
Sir, my question is regarding GPS spoofing and jamming, which is also disturbing the entire aviation industry and the maritime industry too. So now, what should be the possible preventive measures which we can take, or the laws which can be developed? Because as of now, the UN resolutions are not binding. And the thing is that only resolutions by certain stakeholders are being passed, but which is not binding.
Correct. So as of now, you don't have any prohibition under the Outer Space Treaty. Right? The space treaties are not prohibiting any of these things. Only thing which you can refer to is Omera manual and Tallinn manual. Right? There are two manuals which have been developed, Omera and Tallinn. Right? And the states have also agreed, some of the states have agreed that actually these are the rules which need to be followed in any kind of a hostility. Right? Cyber attack, spoofing or jamming, all these kind of other things should not be done during the period of the war. Has been something which the states are coming to the consensus, but there is nothing which is binding. It's not, again, these manuals are not binding, right? Therefore, current international law does not prohibit all these activities.
Sir.
Yeah. Yes, bro. Any follow-up?
No, I was just saying thank you.
Okay, okay. Kaushal?
Sir, I wanted to ask whether the registration convention which we talked about. So I come to know that in Article 2 and Article 4 of the registration convention, there has been given an immense discretion to the state that whatever they want to register for as a space object, they have the right, and they have the right to give information. So they can hide also, no?
They can?
Means, just for example, like some country is having an anti-satellite weapon and they are not registering it. You know, of course, and outer space, it is against the ethical principle of outer space treaty, but they are not registering it, and somehow it makes the convention also weak, na?
No, that is true. That's why I told you, the registration convention is only on the basis of the cooperation, right? And that is the reason why they did not even incorporate a provision for a sanction for failure to register, right? So that's the problem, which is and one of the things which we should keep in mind is that the registration convention is the 1975 convention. Nobody foresaw the possibility of extensive use of the outer space for different military purposes, or maybe even the private entities carrying on the space activities. So precisely because of these reasons, right, you don't find actually any major practical significance of the registration convention.
But sir, with the new development, right now we are seeing the spacefaring, space tourism, and it also conveys the, it also means kind of questions the convention also, registration convention. What about these things also?
No, see,
Are we taking it?
If you look into the national legislation, most of the countries' legislation speak about the information to be given to the states and state transmitting those information to the UN registry. Right? They are basically providing that to a greater extent. And then another thing which you need to keep in mind is that the registration convention has the mandate, or maybe the kind of an objective of having the transparency, isn't it? or having especially maybe the identity of the space object. So at least to whom belongs actually. So that was the ideology behind the registration convention. Now, it has become practically possible to track the space object and find out to whom it belongs, right? Even without the registration also. So if you look into actually certain agencies in the United States or certain agencies in other developed part of the world, they can track and find out to whom it belongs. So even without the registration also, the purpose can be served through this particular practical process of technology. That is why nobody is focusing more in terms of the registration convention, right? But still, national laws, if you look into, many countries do say that private players need to give the information to the state. State has to transfer the information to the UN Secretary General. You can find that actually.
Thank you, sir.
Yeah, I think there are many who are asking for actually any book to refer. I can't recommend any book as such actually, because space law is so vast. There are different areas, so I can't say that one book reference would help you. Bin Cheng has been the authority, but it's very costly. I don't know whether you'll be able to have access. That is why what we have done is that my last book by the Oxford University Press, Space Law, on the space law itself actually, the Western version was very costly, but now they have come up with the South Asian edition. So I recommend it for that because it contains all the basic aspects about the space law. South Asian edition, they have come up now actually. So if you are interested, you can opt for that because it's available at I think 900 rupees. They have kept it very low for the market here. Otherwise, it was $200. So now they have kept it around actually the same 900 rupees. So anyone can go through that. Stephen Hobbs' book on space law. The Stephen Hobbs' book is more in terms of the national space legislation. So if you want to explore into that, you can also do that. But again, as you know, they don't have the South Asian edition. So they're all super costly. I don't know whether you will be able to have access to it, right?
Sir, there is one query I have, like question.
Yeah.
So Kessler syndrome is not included in hazard or harmful activity in space, outer space?
No. It is a problem because see what happens is actually the debris is going to collide with another debris in another orbit, and then it becomes actually cascading, having a cascading effect, right?
Cascading effect.
Cascading effect, and at the end of the day, all orbits being filled with the debris, right? The pieces of the debris. But the issue is Article 9 is not addressing that adequately. Article 9 only says about harmful contamination, right? And
only
that
the contamination part.
Absolutely. So how do you say it as a contamination is the biggest issue, right? Practically, it is a big problem. If you look into the NASA's website about the debris, it's a very scary.
Yes,
it's a very scary picture. Your low Earth and the middle Earth orbit is completely filled with debris, right? And with
Yes,
this syndrome, there would be more and more debris which would be created in different orbits, right?
Yes,
so, but how do you tackle that? One of the options which they have thought of is to go for the guidelines now of exactly to reduce down the number of components of the launch, how to use certain kind of object which would not fragment into pieces. The experiment is going on with respect to that. Right?
Yeah, China is working on it to collecting the debris.
US is also working on that. US has also been working on that using a rubber type material so that actually even if there is a kind of an impact, it would either withstand the impact, or even if it breaks also, it would not break into pieces. Rather, it would become a kind of a ball, right?
They are creating that also to collect the.
Yes. They are also creating the robotic arm to the collection of the debris also. They are also trying to do that. But how safe it is, it's all actually a debatable issue.
So we can say that there is no individual responsibility towards the debris.
Because of the weakness in the outer space treaty. That's what I should agree for. Right? But of course, as I said, this is not something not understood by the world community. In 1980s itself, they had proposed for a debris treaty in the UN corpus, but could not actually conceptualize.
Yes, sir.
Yeah.
Thank you. Thank you.
Sir.
Yes, Santosh. Yes.
Yes. Hi, sir. Thank you so much for this insightful session. My question is, sir, the Outer Space Treaty and the national legislation, do they actually address the concept of like real estate ownership or land claims in space?
That's what I was supposed to discuss in one of my slides, actually. If you look into the Outer Space Treaty, Article 2 is the only major provision. Article 2 says national appropriation by claim of sovereignty, use or occupation, or by any other means is prohibited.
Okay.
Now, there are instances wherein the land claims are made. You can find www.lunarembassy.com. An American entrepreneur by name Dennis Hope is selling the property rights on the moon and other celestial bodies. He has sold it to people. More than 7 million people have purchased the property. Right? More than 7 million people. You can go through his website. He is having all deeds and all, which portion belongs to whom, who has the certification. All those kind of things have been done actually. Right? But who has given right to him? Who has given right to him? Is it permissible? His argument is that treaties are applicable only to the states, not to me. Absurd argument. Because see, in a common law country, US is a common law country. We are also a common law country. All land property belongs to whom? It belongs to state. All land belongs to the state. We are enjoying because of it is a charity, which the state is giving it to us actually. Right? It's a charity of the state. So precisely because of that reason, unless the state owns something, it cannot grant it to an individual. Unless the United States is owning that, it cannot grant it to Dennis Hope. So that's the first thing. Second thing is about mining of resources. You are also mentioning about actually the resource exploitation. Can there be rights over the resources, etc. United States has come up with the legislation. You must have heard about 2015 Asteroid Act, wherein they have permitted the private player to mine the resources, get the ownership of it. Subsequently, 2017 Luxembourg has come up with the law. 2019 UAE has come up with the law. 2021 Japan has come up with the law. All of them for the resource mining, permitting the private players to take it off. 2023 in the Indian space policy, we have blindly incorporated the provision from the 2015 US legislation. One provision we have incorporated saying that anyone can take the resources from the celestial bodies. So that's how the development has taken place. Added to that, in 2020, United States has also come up with Artemis Accords. Artemis Accords, non-binding soft law, but for actually exploiting the resources from the moon and other celestial bodies with the cooperation from different countries. India has also signed the Artemis Accords. India has also signed the Artemis Accords. But to me, all of them are not permissible. Right? And my next book is on that itself, actually. So it's going to come up in September. In September this year itself. It's already, the cover is already available. It's Springer Nature. Springer Nature is publishing. So it's already available. It is not permissible because Article 2 is prohibiting national appropriation by multiple means. Claim of sovereignty, 1. Use. You can't use it individually also. One single country individually doing that for self-benefit is not permissible because Article 1 says benefit and interest of all countries. Do everything for the benefit and interest of all countries. Use. Then it says occupation. You can't also occupy a particular part and say that it belongs to me. Right? Or by any other means, the last part is wide enough to cover by any other means even resource exploitation individually. You take resources and say that it belongs to me. How logical it is. See, even the mining rights on Earth, how the state grants the mining right to any company? Only when
We
the
need
state
a license.
Yeah, through the licenses, correct. But when only when the state is having the territorial right, it can grant the mining right below that the territory. Otherwise, how the state will grant the mining rights? Right? So precisely because of that reason, Article 2 is the crux of it. And unfortunately, there's a lot of misinterpretation of that, saying that it is only prohibiting the national appropriation. State cannot appropriate, but privately people can do anything therein. Absurd argument. That's it. It doesn't make any sense.
Sure. Thank you, sir. Thank you so much.
Excuse me, sir.
Thank you, sir.
Yes, please. Yeah. Asta?
Sir, Anirudh, sir.
Anirudh, yes, please. Yeah.
Sir, what is your say on the environmental concerns on account of increased space activity and operations?
Again, my papers are available with respect to that. I have written in the Annals of Air and Space Law, the McGill University's the journal, primarily in terms of how the international environmental law should also be applicable in outer space. Right? Currently, we have one of the weakest provision in the outer space treaty, Article 9. As I told you, it only prohibits the harmful contamination. But public international law is also equally important because Article 3 of the Outer Space Treaty clearly says that outer space is also governed by public international law, including the Charter of United Nations. Right? Public international law, including the Charter of United Nations, is applicable in outer space. So wherever the Outer Space Treaty is weak and has got the loophole, you have to import it from the public international law. That is why I argued those earthly principles of international environmental law, including, like, say, the duty not to cause transboundary harm, precautionary principle, polluter pay principle. All these principles should also be applicable with the necessary modification for the space activities. That has been argument, but unfortunately, in practical terms, it's not happening. That I should acknowledge.
Thank you, sir.
So following up on this question, if we follow the principles of public international law, so in that case, use and exploitation of the resources should go hand in hand, because it is a customary practice of exploitation. But the jurisprudence over that was entirely different, but still the principle has been developed in such a sense that exploitation should go hand in hand.
Please keep in mind, there is a distinction between the lex specialis and lex generalis. Right? You must have heard about lex specialis and lex generalis. Whenever the lex specialis is existing, you should give preference to the lex specialis. It would override the lex generalis. What does Article 3 say? Article 3 speaks about the application of public international law when your lex specialis is silent. Right? Wherever the lex specialis, that's outer space norm, is not very clear and it is a silent, then you may have to apply the public international law. In terms of use or exploitation, the outer space treaties are very clear. What is permitted is only use, not exploitation. It is clear. Because if you look into the drafting history of outer space treaty, as well as the Moon Agreement, which I told you, Article 11.4 and 11.5, they make very clear distinction between the use and exploitation. Once that distinction has been maintained by the drafters, you should respect that, since it is lex specialis, and lex generalis would be overridden by the lex specialis. I hope you understand that.
Yes, sir. I have some serious questions.
Yeah.
So first thing that when we talk about the Golden Dome, so it has to be barred by two articles, Article 4 and Article 1. But if we see if you see the drafting of Article 4, it is quite vague. However, when we talk about the use of Golden Dome for the purpose of security, it will be naturally using some weapons for that purpose. So isn't that somewhat covering the scope of Article 1 and Article 2 if read collectively?
Article 1, absolutely, you are correct. Article 1, an argument can be made, but unfortunately the problem is that in most of these circumstances, what the US presidents have argued is that it is going to provide a kind of a shield to the entire world. Be it the Star Wars program, the Strategic Defense Initiative, when Ronald Reagan proposed, or be it Trump now, what they are advocating, they are saying that this is for the interest of all their ally countries. They are going to actually construct in such a manner that any ballistic missiles, when they are soaring from any territory, they will be intercepting, helpful in terms of actually negating any threat to the different countries. So that's how they are trying to show that it is for the benefit and interest of all.
But keyword is allied countries must.
Pardon me?
The keyword is allied countries must.
They will say that actually if you want, you can also come. Even if you have a bad relationship, you can come and then you can be part of this. They are not saying that actually you are prohibited from entering into this. Does he say that? Look into the statements given. Yeah. Right? So even if it is allied countries also, they will try to showcase as if actually say it is at least helping 50% of the international community. Right? So therefore it will be for the benefit and interest of all. And in that sense, if you go very, very strictly with respect to the benefit and interest, then you might not be able to carry on any space activity. Because say United States, NASA has carried on so many space activities. What kind of a benefit has been percolated into the other countries? And this was an argument also for the 1996 declaration. I told 1996 there was a benefit declaration, right? Because by 1990, most of the developing countries started to argue that under Article 1 of the Outer Space Treaty, you have committed for carrying on the activities for the benefit and interest of everyone. What a benefit we have got. Practically, we didn't get any benefit. That's what they were arguing. But the developed countries argued that, look, all these technological development, be it direct television broadcasting, right? Because direct television broadcasting is the part of the satellite technology, be it telecommunication, right? Or reaching to the remote regions wherein the wire communication cannot happen. All these things have happened by virtue of our technology. So their argument was that this is the benefit which you are reaping. Yeah, but again, that is not an acceptable argument, because those benefits are coming with a cost. They are charging heavily for that, right? They made money out of it, huge money out of it. But whatever it may be, their argument was that, that even the benefits have percolated to the rest of the world out of their activities.
Sir, this could be, this has the potential of causing a, bad precedent for the countries who has the potential to do the same. And they have the defense. For example, take it US and Russia. They both won't be on the same page in any condition. So if a Golden Dome project is approved and there is no UN resolution with respect to same, Russia would be moving ahead with the same. And there are other countries, China for example.
Perfect. Even look into actually other activities, the commercial activities also. So one country is starting, other country wouldn't be competing with them. There would be competition from other countries also. The same situation would arise therein also, right? How do you say that actually it is for the benefit and interest of everyone? Isn't it? So you are telling from military angle. Military angle, okay, there might be possibility of actually say different blocks coming up with a different kind of military activities. Even in commercial space activities also, because see, US, whatever commercial space activity it has carried on, it must not have given actually the benefit to the Russia or maybe to its allies, its Cold War allies. It would not have given. They should have developed their own technology, like the GPS and all. They have got the parallel technology, right? So how do you say that the GPS developed by the United States is beneficial for the entire world? It is not, right? In the same fashion, Trump is going to argue that Golden Dome is beneficial for those who are part of it. That's it. But I understand your concern that it's not the benefit and interest of everyone. But what I'm trying to put forward is actually the argument which they put forward for defending their activities. Right? These are the arguments. Even during the Cold War period, the Star Wars program, Ronald Reagan defended it the same fashion. He said it's a defensive activity. It is going to give global coverage. It is going to actually help everyone to shield their territory from the ballistic missiles. That's how he put it.
Thank you, sir. I have another question. So, during my internship, I came across the biological experiment that has been carried out in the space. Not in India, private entities have now entered due to commercialization of space. However, there is no strict guidelines or anything with respect to carrying out biological experiment in the space. Neither international law is pretty clear about IPR rights in the space. So how do we deal with it? Because with respect to IPR rights, the international law has stated that it is upon the nations to draft their policies and accordingly grant the IPR rights to the.
Again, you are referring to my another article, Journal of Space Law, 2010. So it's an article on the invention of space. Right. Anyhow, let me just first address about the biological experiments. COSPER has come out with the guidelines. Committee on the Space Research, the COSPER. Right? It had come up with the guidelines. Earlier, for the purpose of preventing biological contamination, they had got a stringent guidelines. Initially, those guidelines were developed presuming that the outer space also has got organisms, biological organisms. So precisely because of that reason, there might be requirement of the quarantining the space object or taking certain precautionary measures, etc., etc. For those purposes, the COSPER has come out with the guidelines initially. But then, when the international community realized that there is no other organism, we couldn't find anything actually till now, the guidelines have been relaxed to a greater extent. They have been relaxed to a greater extent. Biological experiments, we don't have any separate norm to regulate that, right? Therefore, until it becomes a problem, as of now, we didn't find any major problem. Until it becomes a major problem, probably we might not have any norm on regulating the biological experiments. Coming to the inventions. Now, in my paper, there were two parts. First part has been with respect to can we grant the patent for an invention conducted in the space, especially the product patent. Because invention or patent rights is a monopoly right. Outer space law speaks about the common rights. Resources therein are the common rights, etc. We have discussed. Suppose if somebody invents something, especially the pharmaceutical product inventions are going on, that's a possibility of having breakthrough for different kind of diseases in the outer space. So, so therefore, actually, somebody might invent something by using the resources available in the outer space or the celestial bodies. Then they may try to claim a patent, a product patent. Process patent is fine. It is more in terms of an intellectual creation, but product patent is on the basis of the product. The person has produced that particular product by having an input of something which is subject to the common rights. Now, can he get a monopoly right over this, which includes the common resource within the ambit of that? That's one of the biggest debate in terms of granting of a patent. On a contrary note, we also have actually problems with respect to the infringement of an earthly patent in the International Space Station. Earthly patent, right? Say, on Earth, something has been patented, and you know that there is no international patent law, as you have rightly pointed out. It could be domestic laws. You need to register your patent in different countries depending on where there is a possibility of infringement. Like suppose if you have invented something in India, you might think in terms of registering that in US, Canada, Japan, or other developed countries, wherever there is a possibility of infringement of your patent. And protection is granted only within the territory of the state where the patent is registered. Patent is registered. You don't get it outside the territory. Now, if your invention is infringed in outer space in some international space station, how will you deal with this? Whose law you are going to apply? Which court is going to try this matter? But you need to have jurisdiction. For trying this matter, you need to have jurisdiction. Is it actually the jurisdiction of the country to which the space object belongs, where the infringement has taken place? Is it the jurisdiction of the country to which the person belongs? You might be, say, for example, in the US module of International Space Station, you might find a Canadian national. You might find a UK national, right, who is infringing the patent. So which law are you going to apply? Are you going to apply UK patent law, or are you going to apply US patent law, or are you going to apply the patent law which the infringer want to get it applied, or with the patent holder want to get it applied? Patent holder, right? Which law are you going to apply is debatable. Jurisdiction, is it US court which should try, or is it UK court which should try? Who should try? All these are the debates which are still unanswered. And of course, there was actually a debate in the Unispace 3 in 1999. They wanted to have a kind of a cooperative treaty with respect to this, which WIPO in conjunction with the UN Corpus need to develop. Right? WIPO and UN Corpus, they were asked to actually develop it together. Nothing happened really good. Right? So usually those kind of recommendations doesn't get conceptualized unless the problem arises. And until now, since major problem did not arise, you don't find any treaty which is coming to this. I hope it
answers my question. Yes. And the last question, I went through the NGP authorizations for InSpace and also the Indian space policy. So after reading that, I narrowed down, according to my understanding, it has restricted the scope of research and development with respect to the non-governmental entities or the startups. Let's say, and the ISRO has been given specifically, the wordings has been used that research and development shall be carried out by ISRO.
ISRO, yes.
And, yes, sir. So what is the logic behind that? I mean, Indian startups has that potential to carry out a research and development.
It is not prohibiting the research and development by the Indian startup. What it is doing is that it is making ISRO as the predominant body in terms of the research and development. Why? There are two reasons. One, that the ISRO has got already the long-standing history of the research. Now they have to develop on that for further research. But the startups are supposed to start from the scratch, right? They would not be getting anything free. ISRO is having something freely available, so it can develop further on that. That's one reason. Second reason is that if at all the ISRO is going to compete with the private players commercially, most of the private players will not invest in the Indian sector. Most of the private players will not invest because ISRO is already having the technology and it is having a competitive advantage over and above these private sectors. And if the private sector is investing therein, they might not even break even. They might not be able to make profit. So that is the reason why the Indian space policy confines the ISRO's role as a facilitator. In terms of the research and development. And then whatever they develop should be commercialized through the channel of New Space. New Space. They have New Space, right? New Space has been established for that actually. So New Space would commercialize that, and the private player can use those technology for their space activities. That's how they have done it in the space policy. right? It is primarily to address the concern of competition between ISRO and the startups, the private startups who might not be able to compete with the ISRO. But whether it is correct approach or not is a different issue. We have different views on that. But whatever it may be, this is the reason behind it.
Exactly. So, I mean, if we are tracing, if we are going by this logic, so we are just seeing the competition at the domestic level or at the root level. But however, in various countries, there is not such a restricted approach. So, in that case, even the private entities are doing very well than the national organizations of that state.
The private entities are not prohibited in R&D. To be very precise, so don't confuse with that. If you look into the NGP and also actually the space policy, it does not say that the private entities are not permitted to carry on the research. What it says is that ISRO is predominantly for the research, right? It's only saying like that. In other words, if ISRO is developing some new technology, it can be commercialized. On the one hand, ISRO is focusing only on R&D. On the other hand, the private player can purchase it and then straight away go ahead with the space activity, implement that, right? So that's how they have channelized it. But at the same point in time, if any private company want to carry on the research and development indigenously and develop it, it can also very well do that. There is no prohibition in any part.
Does ISRO have an oversight role over private development of technology relating to space?
ISRO has?
Oversight role. An oversight role.
Absolutely no. ISRO has no oversight role at all in the policy or NGP. Look into that. It is only in space which has got the power. In space, right? Okay. Indian Space Research Authorization Center. That's the only thing which has got actually the power. ISRO is not in the supervisory power anymore.
Okay, sir.
Yeah.
Sir, excuse me.
Yeah.
Sir, can you please tell me about some career opportunities in this field? Because for me, it is a brand new field of law.
Couldn't hear you. Can you repeat?
Sir, can you please tell me about some career opportunities in this field? Because it is a brand new field of law for me.
So, as I told in the beginning, see, for the lawyers, there is ample. I mean, if you ask me, actually, in the 21st century, currently the most happening law is the space law. Most of you might think that, oh, what is that? There is only academic interest. There is nothing else. Absolutely not.
But sir, as you said earlier, that in India it is not that much applicable till right now.
You have got 300 startups coming up, right? So when we drafted the national space legislation, we had to defend it in Bangalore. There's a mega event. Minister of Technology came and he basically inaugurated that particular the event. We had actually 300 startup representatives coming therein and discussing every part of it, right? That was back in 2022. Now, InSpace is already licensed for more than, say, 40 private companies. So all of them are carrying on the research. All of them have got substantial support on, on monthly basis. We are also getting a report from the InSpace with respect to what fund they have already actually generated, right? There's a InSpace newsletter, which basically shows us, of course, I mean, it's circulated only for us, I think. But anyhow, it shows how much of the fund they have already generated. Recently, we had a GLEX, Global Space Exploration conference in Delhi 2 months back, right? Yeah. So we had the conference wherein all these startups have come. There is a lot of debate about different aspects, and it is happening at present. So in another couple of years, we will definitely be having a lot of legal issues coming out of it, right? And more than that, as I already told you, a lot of startups have already actually they are contacting. I mean, as of now, since there is no major law firm in India, they're contacting me for all these procedures which need to be complied with for the licenses, etc. Right? I might be actually in a way taking away the livelihood of some people because I'm not charging anything. It's free of cost, which I'm doing it. But whatever. So once actually any law firm is showing the expertise in this particular area, I'm pretty sure that actually there will be a lot of practice even in India with respect to the space activities.
So, in connection with the same question,
yeah.
So, how can we pursue as a law officer? Should we go for the PhD first, or after LLM we can pursue? So, what is the professional way to enter as a law officer?
Law officer, where?
So, in any firm or anywhere work as that.
Law firms would require only LLB. Nothing else is required for them actually. But if you have to show your expertise
in LLB, we are not taught this subject.
Yeah, exactly.
So that's the concern.
I'm just coming that actually. So I'm saying that if you have to have expertise in space law, then you definitely have to actually go to some universities which are offering these courses, maybe aviation or space. At the global level, two universities are top, McGill and Leiden. McGill and Leiden are the two top universities. If you can study from there, I mean, if you're fortunate enough, then fine. Yes, so that would be helpful in terms of establishing your own career. Or even University of Nebraska, University of Luxembourg has a program with respect to it, but they are not top tier like the McGill and the Leiden. But still, you can explore Nebraska and Luxembourg if at all the top two does not conceptualize. Even the University of Sharjah has a program. Sharjah University has a program.
Even the University of Lund, LUND. So
Pardon
they
me?
have a spacecraft. The University of Lund, LUND.
Lund has actually, yes. But more than that, you have International Space University in France. You can also explore that. International Space University is there.
I had a subject in my LLB in UP there.
That is not sufficient. That is not sufficient. You might have a subject, but you need to show your expertise. Maybe through publication, maybe through conferences. Yes, you can show your expertise because in different conferences, as I told you, the conference like GLEX, you will have the private companies representatives coming therein, right? So on that, there is a possibility for getting the contacts. Yes. Gaurav?
Sir, my question pertained to the book that you were talking about, that was South Asian edition. Sir,
Yeah.
actually, I and many of us could not hear the name of the book. So in message section, there were multiple messages with regard to that. So what is the name of that book, sir?
International Space Law in the New Space Era. International Space Law in the New Space Era. Oxford University Press, the publication. Right? So I think even in Amazon and anywhere it's available. Actually, it's available. It should
Yes,
be.
sir. Maybe.
Yeah.
Yes, sir. I think I saw this book in our library as well at NLS Library. So I believe that we have this book. Thank you, sir.
Right. At that time, actually, it was very costly. Now the new one has come very recently. Right? This South Asian edition has come just in the not even last. I think maybe 15 days back must have come. So the earlier one was actually the Western edition, which they keep it around $200, not less than that. And this, since it has the potential to become a kind of a basic reading material for even all students or maybe any university, they have actually published it in the softbound South Asian the version.
Thank you, sir.
Then, Shreya Sri? Yeah.
Hello, am I audible?
Yes, you are. Please.
Good afternoon, sir. It was a great pleasure to attend your session, first of all.
Thank you.
So I have a question which might sound a little absurd, but just speaking on realistic paradigms. So personally, I have been very interested in space law for like the past 4 years. I'm in my final year right now. So since first year, I have been very much invested in space law, but somehow it always comes to that same standpoint, whether it is a realistic dream to pursue it, because financially everything all been considered. So say if I want to really pursue space law after earning for some time, say in policy making, I want to get into in space law, how feasible is it for Indian students? Because not for all students international endeavors would be accessible, right? So for Indian students, how realistic it is?
No, I should say it is definitely realistic. It is not directly something beyond anyone's capability. McGill and Leiden have got certain scholarships as well. There are scholarships which are available. So you can just explore that. That's number one. But for that, you need to have a strong CV. I don't know about your CV, how strong it is. Because by the time you come to the final year, you should have actually got at least some 8 to 10 presentations in conferences, maybe say at least 4 or 5 major publications. If these kind of things have been done, and in addition to that, if you have got good internships in some of the top level the firms, or even an academic internship with some professors in aviation or space sector, all these things cumulatively can help you in terms of getting to maybe universities like McGill, Leiden, or even along with the scholarships. But if you don't have such a kind of a strong CV, one of the options is to work for a couple of years, as my own students have done it in many instances. But during that process, you should be very determined, and you should also be actually doing this work, which I basically pointed out, maybe conference presentations, publications, or even any other kind of the things, whatever is feasible for the purpose of building your CV. If you can do that, then probably you'll be able to get through along with the fellowships.
That really answers my question. Thank you so much, sir.
Right.
If I may, sir,
Yes.
I'm sorry.
Yeah.
I'm Virginia. I come from Italy, where I currently live and study law. And I would like to just say something about the topic of space law and the importance of studying it, because I can see from an European point of view that it's really coming to something. Just recently, the European Union approved a first draft of an European Space Law Act. And also I can see that in Italy, we have just recently, as of last month, approved our first
your own space law has come up, yes.
On space economy. So it's really, I do believe that it's something really important for the future. And I think that I cannot obviously relate to the students in India, but I do think it's that here in Europe, we have a lot of opportunities. And also I can see globally that there are new opportunities coming. And I do believe that, like, as we did in Italy, also in many other states, they are approving new space law acts. And so I think it's something that for the future is going to be really, really demanded.
Absolutely. I completely agree with you. And in fact, actually, when you say Italy, my best friend in space law is from Italy, Fabio Tronchetti. I don't know whether you have heard of him or not. Though he's in UK now, he's in he's a professor in UK right now, actually. But yeah, he's from Italy, and your national space legislation has been contributed by him, to be very precise.
Yes, yes.
You can also Google Fabio Tronchetti. Yeah. Yes. Yeah, of course. Yeah, as she has rightly pointed out, there is a lot of development which is happening, not just in Europe. Yes, in Europe also there are a lot of countries which are having their own independent legislation now. Even in Asia also, Middle East countries also, you will just look into UAE, Saudi, and all. They are all developing their own the national legislation, right? And South Korea already has got the legislation. Then Japan has come out with the legislation. So like that, even the Asian countries are also developing their own legislation. And legislations don't come into force as long as there is no practice. They are actually developing primarily because of the space law practice is evolving in these the parts of the world. Right. Aditya?
Thank you very much, sir. Good afternoon.
Yes,
So my
afternoon.
doubt was pertaining to space debris per se. So hypothetically, let's say a satellite or a space debris collides and it forms a chain reaction per se, which leads to a series of collisions. Where would the aspect of liability stop?
No, liability will not stop, because actually at the end of the day, it's on the basis of the fault-based liability under Article 3 of the convention, right? So whoever is at a fault would be liable for all the chain the consequences out of their activity. So liability will be immense in those circumstances. But still, there is an argument to be made. As a lawyer, there is a possibility of an argument.
Yes, sir.
What is that? Should I also tell?
The satellite was not functioning per se, and it is not in the.
No problem, because actually Article 3 of the Liability Convention does not say an active satellite. It says a space object. Any space object, if it is causing damage, the launching state is liable to pay the compensation. Right? Okay. So space object would include even the defunct satellite. It is not. Yeah. It need not be an active satellite actually.
Yeah.
But there is a catch under Article 3. Not just under Article 3, even Article 2. Aditya is going to cover that in his presentation, I believe. But still, let me just tell you, if you look into Article 3 of the Liability Convention, it says about the damage caused by the space object. Damage should be caused by the space object. And if you look into the definition of the space object, it says it should be either the satellite as a whole or component parts of the satellite, launch vehicle, or its parts.
Yes.
Right? I don't know whether you have the Liability Convention in front of you. It says, right, satellite, component parts of the space object, then launch vehicle, and the parts thereof. Now, the problem is with the first part. It says component parts of the space object. Second part says launch vehicle and parts thereof. Any part of the launch vehicle, if it is causing damage, then liability is there. But unfortunately, first part, they mention component parts of the space object. What does this mean? Component parts, most of them argue that separately identifiable parts. Separately identifiable parts. If it is actually a piece, a particular piece which is not a separately identifiable part, right? So separately identifiable, like say fuel tank, or maybe any major module of the space object, transponder, all these things should be separately identifiable. What if it is a part of a fuel tank, small piece of a fuel tank, which is hitting some other satellite, causing damage? A lawyer would argue that it's not a space object. It's not a space object. It's a part of it. And Article 3 does not mention part of a space object. It is saying component parts. Right? So that's why there is a possibility of a creative argument. There is a possibility of misusing all these things. Right? So, and obviously there would be more scope for the lawyers by virtue of this loophole.
Yes, sir. Thank you very much.
Right. It's just a hint of that actually, but there are so many other arguments. Probably you will discuss that further when Aditya is covering the liability convention.
Sure, sir. Sure. Sir. Thank you, sir.
More questions. It has been 45 minutes since the end of the session.
Sorry to interrupt, sir. We have already passed the time duration, the planned time duration. But if you still wish to take up the doubts, we can move forward.
Right.
However,
you have a next session beginning at what time?
No, sir. We don't have any session scheduled for today. We have a next session scheduled for tomorrow only.
Okay. So if you don't have any problem, I can answer because I'm always available for space.
Sure, sir. Then obviously you can take up the doubts, sir.
All right. Yes.
Good afternoon, sir. This is Professor Bhanu Advani. I have a query. Sir, what is your perspective on Elon Musk Mars colonization project in the context of existing international laws? Also, do you believe his plans align with the current legal frameworks, or will new laws be required to support such private space endeavors? So what's your take on that?
As of now, it is not permissible as per Article 2 itself. I've already told you about actually the non-appropriation by sovereignty, use of occupation, or by any other means. How it does not become appropriation by occupation. It would definitely become the appropriation by occupation. Their argument is that what Article 2 prohibits is only the states. It is not prohibiting the private players. It's an absurd argument, and this is not permissible at all. Right? So if any such kind of a human settlement is to be explored, that should be with the collective efforts. Maybe through the United Nations, some new development need to take place. And on that basis, they can go ahead with actually the human settlements or the habitation, etc.
Okay, sir. Thank you so much.
Thank you.
So I have a doubt.
Yes, please. Who is in
Sir, as on Earth, we can see that the countries are not following the international laws, international treaties in any case, though they are parties to it.
I couldn't hear you. Can you repeat?
Yes, just a sec, sir.
Yeah.
Yes, sir. So can you hear me now?
Yes, better. Tell me.
So, if we see the current global scenario, the countries are not following international treaties and conventions which they have already signed or attested to. They are not following in the case of land, water only. But in space, how can we guarantee that the country would follow the treaty or stay abide to it?
Okay.
Because it brings a lot of problem.
Let me tell you a counter question. Sexual harassment in workplaces. Don't you have a law?
Yes, sir. Yes, sir.
Sir, there is a law, sir.
Or isn't it continuing?
So it is continuing, but there is a legislation to it, sir. And
here's also the same thing. International treaties you are having. If somebody is actually not following that, it is actually a rogue state which is not following it. In the law also, I mean, see, simply because you are having IPC or maybe now the Bharatiya
BNS.
Yeah, BNS. Is it that actually crimes are not happening? There are people who are not following it, and they're punished for that actually. Same thing is also there in the international level, but only thing is that when a big player is actually, say, violating the international treaty, it becomes extremely difficult to punish them. And the same in the municipal law also. So some of the big shots, if they're doing something, they would escape from the liability in many circumstances actually. So therefore, when we are telling about the legal norms, we cannot say that actually it's a perfect scenario wherein no breach would happen. Breach would happen both in the domestic level as well as in the international level. Only thing is that how effective is the remedy available in those cases.
So there's one more follow-up to this. The space law resolutions are passed by the UN, United Nations. And there are, we also know that there are 5 countries which are influential into UN, and UN generally functions according to them. US, we can consider US and UK, there's Russia there. So how can we say that UN would act fairly there, not regarding the profits of these countries?
No, see, in the United Nations, only in the Security Council level, the 5 permanent members have got the special power.
Yes, sir.
But in the UN General Assembly, there is no special power. In the UN GA, it is only based on the basis of 2/3 majority. Right?
Yes,
so it's not a veto which is available to any of these the countries in the UN General Assembly, and all these development, whatever have taken place, is on the basis of the UN General Assembly's resolutions, not the UN Security Council resolutions.
Okay, sir.
Yes. Who is next? I can't see. Yeah.
Sir, my query to you is that there are 2 major laws, like in India, that is still not being put forth, that is in AI and space. Is there any specific reason why we are not moving forth in this field? Because both are dependent on policies, not legislation. So is there like one, or why is it? Because we want development, growth of technology, or we think that these will cause a hindrance? Is that the reason, or is it just
No, I mean I can
political?
I can tell you only about the space, not about the AI, since actually I work in the AI. One of my students do work here, and who is my colleague here now actually. So he works on that. He has a different opinion. That's the different thing. In terms of space, as I have already pointed out, one of the major issues initially has been about the discretion of ISRO. Right, so they were really skeptical whether actually the powers would be curtailed, whether the budget would be cut down. All those kind of things were going on initially. When 2017 draft was made, also they did not consult us. Final consultation was not made, and then subsequently they themselves have come up with something. Then they realized that there are problems. The draft which they have created is a problematic the draft, and subsequently for the first time they asked for the legal experts to draft it in 2022. So we drafted the law. Obviously, it would route to the ISRO only, right? So even though actually it goes to the PM's office, because the Department of Space is directly under the Prime Minister's office, it is routed through the ISRO. And there are many people in the ISRO itself who have problems with the different legal aspects. So precisely because of that reason, I'm not very sure actually what has gone wrong, because ultimately that should have been some kind of a feedback from the ISRO or maybe some people in the administration therein, which has resulted in holding it back for a long period of time. But now, last news which I have heard is that this year it is going to be placed, 2025, by the end of this year it should be placed. So if that happens, probably I think a great thing for India. Let's see.
Okay, sir.
Right. And I have also written on this aspect, because you can't develop a policy and implement that without a legislation. All of you are also the students of administrative law. I think you must have studied in the graduation level. You know that the executive cannot action without a legislative framework, right? You have the executive excesses which have happened, and in multiple cases the Supreme Court has struck down the executive action on the basis of ultra-virus principle, substantive ultra-virus. So multiple cases are available in the administrative law. And one of my papers on this is available in our own journal, Lex Ed Coilum, our own center's journal. It's available online. So if you can Google through that also, you will be able to get some idea about how exactly we are not correct in terms of having a policy being implemented without a law being drafted.
True, that is why the question, because 2 major frameworks like the AI and space are not being regulated by legislation, but only by government. That is why the question. That's the reason. Yeah.
Correct. And also in space, they have established a body like in space. That in space cannot come into existence without legislative backup.
True.
Right.
Even for AI, they have established a couple of bodies via policy, like Airavata and stuff, if I'm not mistaken.
Distinction. Let me just tell you another distinction. Because in AI, you don't have a treaty like the Outer Space Treaty. Here you have outer space treaty, Article 6 is saying that even for private space activity, state is responsible, right? Responsible. If something happens, the payment would go from the state exchequer. Our public fund would be spent for these private activities, right? So that's the biggest problem under Article 6. And you don't have a parallel in the AI with respect to that, right? Here we are responsible. We are supposed to have a kind of an authorization and continuing supervision with the appropriate body, and legislator should come up with that appropriate body and not executive. And if you do that, you'll be in trouble in future with the public fund being spent for private expenditures.
True. Thank you, sir.
Sanket? No? Ojasvi.
Yes, good afternoon, sir. First of all, thank you for the session. Sir, I wanted to know your take on that, how the current international space laws account for the cyber security risks that are related to the satellites, because eventually both are interlinked, as there is a legal vacuum when it comes to addressing cyber attacks on space-based infrastructure, and somewhere we can merge these two fields in the upcoming study of the space law as well. So what would be your thoughts on this?
No, see, when the international space treaties were entered into, these things were not at all actually foreseen. Cyber attack and all are not actually foreseen at that time. But of late, as I told you earlier, Tallinn manual and the Omera manual have been developed with respect to the cyber attack and then use of force in space, etc. So you can look into those two manuals. In one of my papers, I have argued that Article 4 has to be widely interpreted, right? Because under Article 4, you have a prohibition on the nuclear weapons or any other kind of weapons of mass destruction, isn't it? Right?
Yes.
Any other kind of weapons of mass destruction. Of course, it might be actually a creative interpretation, but still it is possible. What I argue is that weapon of mass destruction, we should not actually define it on the basis of our earthly experiences. It should be on the basis of the environment where we are trying to define. It's outer space, right? You have to look into that. So on that basis, you have to define it. If you look into the definition of the weapon of mass destruction, there is a UN General Assembly resolution 1978, if I'm not mistaken. 1978, it was primarily in the Conference on Disarmament. With respect to that, they have taken a resolution and they have drafted it as a binding resolution, right? It's drafted as a binding resolution, so it is binding on the states. It uses the term weapon of mass destruction means nuclear weapon, biological or chemical weapon, or any other future weapon developed having the equal destructive effect. This is the definition, right? Nuclear, biological, chemical are mentioned explicitly. Then it says any other future weapon which has got the equal destructive effect.
Yeah.
What we have done historically or over the period of time is to consider only the first part. We have looked into actually say nuclear weapon, oh, mass destructive, biological, chemical, mass destructive. We will take action. But what we left out is the last part. Any other weapon which has an equal catastrophic effect, we did not actually look into that in detail at all. We have to interpret that properly for the outer space, because outer space is an environment wherein even 1 centimeter debris can create a chaos therein, right? So precisely because of that reason, when you are defining the weapon of mass destruction for outer space, you need to look into the environment therein, and on that basis you have to qualify. So if it is a cyber attack, possibly having a result actually resulting in the huge destruction, we should qualify it as a weapon of mass destruction, right? We should qualify it as that. And in that sense, maybe prohibition under Article 4 can be brought in, is an argument which has been developed, but it's just an academic argument, to be very precise. In practical terms, nobody is going to accept it as such.
Yeah, but basically, this is something which might be needed to be regulated in future as well, because we have now various non-state actors, and even not then a majority of people who are knowledgeable enough to access it negatively as well. So will it not hamper the research and everything that someone has put?
It is going to the hamper, and especially actually the private industry might also be skeptical unless and until there is a safeguard to their activities, right? Tomorrow their investments, they might not be able to reap it back. if they don't have a proper remedy against actually cyber attack from others, then what will they do? Right? So
Yes,
of course, municipal laws are trying to look into it to a certain extent, but it is not on the basis of the space component, rather the effect, where the effect has been felt. On that basis, actually, say they are trying to deal with the cyber attacks.
Yeah. Sure, sir. Thank you so much.
Most welcome.
Sir, if you could repeat those two things you asked me to study on this cyber.
Omera manual and Talin manual. Talin. Right?
Okay. Yeah. Thank you so much, sir.
Lokesh, I think the last one. All right. Lokesh, do you have a question?
Sir, good afternoon, sir.
Good afternoon.
Sir, I have a query that.
Please.
If last
voice is breaking.
student is trying to build a career in the aviation field, what are the opportunities we have in future?
I couldn't hear you at all. Your voice was breaking.
Am I audible?
Tell me, yeah. Yeah, please tell me. Lokesh, are you speaking? Can't hear anything. No?
Sir, now it is
Yes.
audible. Sir, now it is audible.
Yeah, please.
Yeah.
Tell me. Yeah.
Sir, good afternoon, first of all. That law student is trying to build a career in aviation law field. What are the opportunities that a law student can have, sir?
No, see, aviation law also provides you the similar kind of opportunities, maybe in terms of liability, for example. Maybe, you know, that recently there is an aircraft, the crash. There will be a lot of litigations we will be flooding into in terms of fixation of the liability of the carriers. Then in the aviation law also, you have the contracts to be entered into, right? So with the carriers having the contract with the airport authorities having the contract with the different actually service providers, ATC contract with the ATC, air traffic control, all those kind of contracts would also need to be vetted. And financing, aviation financing is one of the biggest issues at present, right?
Okay, sir.
Most of the foreign investors and all actually. So if at all they don't get back the money, how to realize that? It's also a legal issue. So all of them
Okay.
providing a lot of opportunities.
Okay, sir. Sir, if I'm trying to build a career, what are the your recommendations, sir? What are your guidance to be a aviation field, to be a law officer in aviation field?
No, you won't get law officer's position as such. Actually, I mean, very few options would be available.
It's like legal advisor, sir. Legal advisor and.
Legal advisor, very few companies would have the separate legal advisor. Otherwise, most of these companies would hire the services from the law firms only. They will not have a separate legal advisor for their company, right? IHL has aeronautical has got actually its own legal officer, but apart from that, you don't find actually any major aviation player having the legal officer separately.
Okay.
Be part of a law firm, and there is lot many law firms who are having actually the aviation law practice. You have Saren and Co has got a lot of the practice, and you have Dua Associates, you have Lutra and Dutra. So all of them are having the aviation law.
Okay, sir.
Right. So still, I think one more hand raise. Advocate Sanjay.
The last but not the least.
Yeah, obviously, yes.
Yeah. So, is it any way that we can connect with you?
Pardon me?
Is it any way we can connect with you?
Yeah, absolutely, no problem. My email, you can note it down.
Please, sir.
I'm not on WhatsApp. I'm not on any social media. I'll do one thing. Maybe I'll just text it here.
Please, sir.
Yeah. You can see it. Sandeep at NUJS.edu.
And any possible possibility you can share your number, sir, if you don't mind?
Sure, no problem.
Please.
Yeah, as I told you, I'm not on WhatsApp, so you can call me. That's not an issue.
Sure, sir. Sure, sir. Sir, number removed, sir. Can you please come again?
No, I think it's there above. It's there above. 99038.
Yes.
54794.
54794.
Right.
And thank you very much, sir.
Most welcome. Most welcome. Right. So it was a pleasure to interact with all of you. So though actually it's more than an hour after the session also. But good to hear that you're curious about aviation and space law. All the very best for the remaining session. Thank you so much.
Thank you so much, sir. And it really means a lot for us for such an insightful session. I mean, like the energy and interaction during this live session truly reflected how impactful your teaching was. And you made a complex and niche topic feel so engaging and valuable. So
I can't hear you. I mean, is there any internet connectivity problem here or from your side?
Thank you once again.
Right. Okay. Yeah.
Am I audible?
Yeah, now you're audible. I think in between I could not hear. It's all right. Okay. Thank you so much. Thank you so much. Thank you. Right. See you. Thank you.
Very sorry.
Thank you so much, sir. It was an amazing session, especially for beginners in space law. It was really good.
My pleasure.
Thank you, sir. We enjoyed a lot. Thank you.
Thank you.
Thank you very much. It was really interesting.
Thank you so much. Requesting all participants to please be active on the WhatsApp group. We'll be sharing all the updates there on time. Thank you so much.